Your Lordship, I would like to mention item number 4.
Yes.
Yes, Your Lordship. So I have taken the consent from the petitioner. Advocate.
You're there, Mr. Tafu?
Yes, sir, I'm for the appellant, madam.
Okay, you're for the respondent.
Yeah, respondent number 2 years.
Okay. You want some adjournment?
Yes, Your Honor. For 2 weeks, Your Lordship.
2 weeks. You're on behalf of Deela ji.
Yes, Your Lordship.
On a request made on behalf of Sri Deela ji, learned counsel, learned amicus curiae.
Amicus.
For
Yes.
the respondent number 2,
Yes, Your
the
Lordship.
matter is adjourned to be listed after 2 weeks. Yes. Sri P. Tafu, learned counsel for the appellant. And who's for the PP? Anyone? Record name? Ms. L. Hage, APP are present.
Your Lordship, I beg to mention item number 3 on
Yes.
behalf of Mr. Titi Tara.
What has happened to him?
We taken consent from other side also.
What has happened to him?
Sorry, my lord.
Hmm? Why are you mentioning? Why are you mentioning?
Oh, sorry, my lord, I'm not getting. My lord, my seniors are out of station.
Out of station. Okay,
Yes.
tell us. Okay.
My lord, matter may be fixed on 27.
After 2 weeks. Okay. A request has been made on behalf of Sri T. Tara, learned amicus, appearing for the appellant. There is a private respondent also.
Yes, Lordship.
Where, have you informed Mr. Lampu?
Yes, okay,
Okay,
I'll inform
yes,
Lordship.
he's there. Miss L. Hage, learned APP, Arunachal Pradesh, and Sri H. Lampu, learned amicus curiae for the respondent number 2 are present. Para, list after 2 weeks. Yes.
Like Lordship.
Wait, lordships. My lord, this PIL was filed, my lord, because of the total lack of progress of work in respect of, my lord, package B of this Itanagar to Bandadua highway. Naharlagan portion, my lord knows what has happened. This work was to be completed on 7th of December 2024, my lord. Was to be completed. Then, my lord will kindly peruse the order dated 8/5/2025 passed by this honorable court.
8-5.
8/5. They filed a status report.
Yes.
On the night of 19, my lord, they put some sand and gravel, and my lord, that is how they are saying that they have done lots of work. In any case, my lord, from Monday, my lord, it appears, my lord, they are attempting to do some work, my lord. They have diverted traffic and all, everything is in a chaos now.
Where is your status report, Mr.
A status
Ratha?
report they have filed.
After this order of
Yes, after this order,
8-5, where,
the contractor has filed, respondent number 7 has filed.
where is the status report?
But I represent the respondent number 7, Lord.
Yes.
Lord,
So
yesterday,
you are supposed to file status report.
yesterday we
Who-
filed, man.
6 and
Mr.
7.
7, my lord.
7.
Who's
7,
6? 6.
I was furnished a copy yesterday, I don't know.
6 is the Ministry of Road Transport. Where is your status? We are not too much concerned about the status report of the contractor. We are concerned about the status report
Copy हमको भी
of the authorities. Again? What do you say?
My lord, technically it is, I couldn't submit and learned DSI is out of station due to health issue. So we have officers, they can explain. From more.
Yes, call your officers. Yes. Okay. Yes, please introduce. Who are you?
My name is Subhash Chandra, sir, Regional Officer, Ministry of Road Transport and Health.
Okay. What, see, this road was to be completed by December 2024.
Yes, sir.
It has not been done. We are in
Now,
the,
when we extended was, sir, July 2026, the main particular challenge is in the flyover portion, sir,
Yes.
4.34 kilometers,
Yes.
sir. So last hearing,
That was decided every 15 days we have submit the status report, sir. The first week we have tried to maintain the traffic at multiple condition, but sir, situation is the heavy rain and construction of flyover. It is, sir, matlab already deteriorating stage, sir. Then contractor has planned. We are also meeting. कि just मतलब go for a permanent solution, permanent restoration, sir. That as per the original scope of work. So he has submitted a program, sir, for 2 months up to 15 July. They will complete as per the scope up to the DBM level, sir. DBM is just 65 mm level, sir. So GSB, WM and DBM level, sir. So full in the full length, sir. 4 lengths, sir. So
By
they have-
July.
Yes, sir. Sir, I have also verified, sir. They have sufficient submersibility plant, but sir, condition is that, sir.
Do you have a clause of liquidated damages or not?
Sir,
What measures have you taken from your side, you being the owner of the work? The work is being executed by a third agency, represented by Mr. Dubey.
Sir,
And these are not adversarial litigations.
yes, sir.
You are also interested that the work should be done at the right earnest within the time specified. And his concern is also that, in fact, the concern of the entire people of Arunachal and the country is that. But we have seen that there has been unnecessary, inordinate, unexplained delay. There may be delay, some delay for reasons, but what measures have you taken? See, this was envisaged that this situation will arise.
Sir, we are not paying price escalations for just such delay payments, sir.
No, that is not a
sir.
punitive measure.
Yes, sir.
Do you have a clause of LD or not? Have you ever thought of invoking LD, liquidated damage? You have not thought of, you have not taken anything. Take steps, automatically things will start moving.
Sir. But sir, up to 15
This
July.
matter should not come to the court. It is your domain.
Yes.
You have to
Sir.
supervise, do it within the time.
Sir,
If
whatever.
there is a real genuine cause for extension, extend by a reasonable time, finish it.
Sir,
At times we understand practical difficulties may arise.
Yes, sir. Some practical difficulties.
What
yes,
from,
yes, sir.
from,
Sir,
what was
but
the,
now, sir, now we
what
are very
was the original tenure of the work?
2021, sir.
No, tenure, by what period?
7 December 2024.
December 7 is
What was the
3 years.
tenure? 3 years.
3 years.
3 years was to be complete in
Yes, sir.
December 2024.
yes, sir.
So we are already in May, end of May, almost mid of May, 2025. So how much is the percentage of extension? So far as tenure is concerned, just imagine.
Yes, sir. Some
And if you are
delays.
saying that by July, you have already almost tacitly given the consent till July, 6 months more.
Yes, sir. Because of sir, this time, sir, this time it not a phases to go for the termination area, sir. You are just I want to complete the work, sir.
Sorry, what was your name?
Subhash Chandra, sir.
Mr. Chandra, we are not asking you to terminate. Terminate will create
Yes,
more
yes,
problems.
yes.
We are more interested in the completion of the work
Yes, sir.
by whomever you want to do engage. We are
Sir-
not asking you to take punitive steps of terminating. Yes, you may also take
Sir,
if
yeah.
they need be. But now the present concern is completion of the work.
Yes, sir.
And
Now,
how
sir, very
soon can you complete the work? What steps? Because these kind of problems are not new to you.
sure, sir.
You face this kind of problem everywhere.
Sir, our DG is also monitoring the day by day. It's WhatsApp group and day by day we are watching, sir. I personally inspected
Your
the site, sir.
efforts,
Or
There
sir,
are
now,
doubts
sir, now this work
expressed by
program.
this court on earlier occasion,
Yes,
your
sir.
sincerity.
सर अभी जस्ट इन्होंने 15 जुलाई तक का जो इन्होंने स्टेटस रिपोर्ट दिया है सर, मतलब उसमें 15 जुलाई तक जितने भी हमारे सर फ्लाईओवर के नीचे के जो लेन है
You
सर
are
वो
a senior
कंप्लीट हो
officer.
जाएंगे
Kindly employ the court's language.
सर वी
Kindly employ
विल
what is the language of the court?
सर वी विल
Don't
कंप्लीट
speak in vernacular. You're a high ranking officer.
सर वी विल कंप्लीट सर बाय 15 जुलाई सर.
So what is your status as on today?
एज एन
From the last day
as
of
per
listing till today, what is the status?
sir as per जो work program recently submitted by the contractor, the last 1 week sir he has completed.
Have you supervised, have you examined the report given by the contractor?
Yes sir, we examined and vetted by sir.
No, after the examination, have you verified the facts stated are correct?
Yes sir, I verified then I signed sir.
One more thing may I point out that Justice Habong is aware of the locations also. This flyover part, we can understand to an extent, my lord. It should not have been done. At least they are starting something now. But the portion from Model Village to Nirjuli, my lord knows. That road, my lord knows, was constructed. That is totally ruined now. My lord, I pray for a direction that at least where that part there is no disturbances there. That at least that part they should complete. Model
Sir.
Village to Nirjuli. It is
Sir,
total ruins.
Sir,
You
we
know
will
that.
monitor day by day, sir. Every
You do
moment,
it on a day-to-day
sir.
basis.
Day
This
to
is
day
a
basis, we
matter
are
of-
monitoring, sir, or up to
This,
15th July, sir.
this part is the starting of the road from, it's very crucial.
Yes, sir. Just
And
I
it is
know,
not a today's problem. This problem is going on for
sir,
quite some
I
time.
can
Therefore,
understand,
this
sir,
flyover was envisaged.
that I
And
will,
what about this part?
Model
It is
Village to
under-
Nirjuli, there is no encumbrances. It's free from any encumbrance. It's totally ruined, my lord.
Yes, Mr. Dubey, that is
That
your
part, at
part.
least, my lord, may directed.
Are you the contractor in that
Started
part
right
also?
earnest.
Yes, yes, my lord.
But kindly
Village
advise
to
your
Nirjuli.
client. Otherwise, adverse orders will be likely to come from the court.
sir, हम
We
आज
are
से
not
monitor,
taking it as an adversarial litigations, blood, and your lordship is
No,
monitoring.
that is it. But what
It's an
about the
admitted
portion?
point.
What about the portion what Mr. Panging is trying to indicate? From Nirjuli
Model Village to
to
Nirjuli.
model village to Nirjuli, that there is no encumbrance, there is
Yes.
no bridge,
Yes.
there is no river.
Yes.
And we should not bring in personal experience, but we have personal experience.
Yes, yes, my lord.
The
My lord, I
matter
also had
where
personally visited. my
The
lord.
residents are facing lots of problems. Small vehicles cannot even ply now.
Yes, my lord.
My lord, we have
There are
also talked
craters
with the
there, not
administrative
potholes.
authorities, my lord, regarding diversion of traffic, my lord, so that, my lord, the work can be expedited, my lord, and
So,
already,
Mr.
my lord,
Dubey, so far as this part is concerned, the steps taken day before yesterday, we have come to learn. But this
Madam.
portion, the other portion, which
Yes.
Mr. Panging is trying to point out,
Madam.
model village to Nirjuli, what is the problem in executing?
my lord, there also, my lord, we have started the work, my lord. Basically,
No, please
No,
don't say like that.
Mr. Dubey, it's not a question of starting. The
My lord, they have not started.
entire work was to be completed by December 2024. Now you don't say
That's
that we have
true, my lord.
started the work.
No, my lord, I am not, my lord, major part of that, on that too, my lord, it was basically for the construction of road, my lord. My lord, that is, my lord, only difficulty is, my lord, because of the maintenance part of it, my lord, now. My lord,
So
therefore,
you don't
it
want,
has
we
passed
don't
out.
want the contractor or either the engineers or the contractor to come to the court. Their work is in the
Hello.
field. They are not here to come to explain. That
Yes, yes,
situation,
yes.
please do not allow such a situation to arise that they should be summoned to the court to explain. In fact, they are not called, they had come, but we don't
Yes,
want
yes,
them. They should be there, but their time there is more precious.
Model Village to Nirjuli, my IAS officer of the court is making history. There is not a single labor, there is not a single machinery.
Okay, we'll have this after 15 days.
Right.
We'll make an indication of this stretch also.
Yes.
Okay, and we'll record his presence. Okay.
My lord, by this order, dates have already been fixed, my lord. Dates are already fixed.
Yes, Mr. Dubey, yes,
My
my
lord,
brother has indicated, how many, what is your force?
Yes, my
Workforce?
lord, that also.
if your lordship would see, my lord, we have annexed so far as machinery and all are concerned, my lord, in our status report. my lord.
Workforce. We don't find sufficient workforce, not
My lord,
sufficient.
what they are doing is,
Workforce is totally lacking.
for one post for the flyover, there will be one JCB, that vehicle. There will be around 11, 12 laborers, nothing else, my lord. One by one they are doing. They are supposed to 149, my lord. They have already
Who is the
constructed 50,
contractor?
my lord.
Done by whom?
Udil Sivam, the client
Number
responded
7,
by
my lord.
Mr. Dubey presents.
Mr. Dubey,
My lord.
you want this to be your last work or what?
No, my lord,
It appears that you don't want to work after this.
no, my lord. It's
This
not the
also
case.
is started
Earlier,
after-
If
my
you
lord,
are having this, if your work is reflecting this kind of an attitude, that for one, you have seen what is going on in Guwahati, you are not appreciating too much. But at
Right.
least something is better in Guwahati. For one post, have you seen how many machineries are used?
Yeah, that
What
is
is the
what
workforce? They are working whole night.
we see, my
Even
lord,
there-
Guwahati.
There we have no, we can take judicial notice, there are only 3 hours of working spaces there. Every day because of the hazards of
Yes, my lord,
traffic.
Guwahati,
Only
the-
3, only 3 hours every day, they have progressed. They are progressing. May not be to the desired extent, but they are. But here nothing is going to,
my lord,
whatever
Guwahati
we
progress
see
is
now,
unthinkable compared to
3 months
Arunachal.
before when it comes, same thing, nothing, no development. Why?
Lord, some temporary works were done, Lord. I could not come personally, Lord, because of my some personal difficulty
No,
on
no,
my
no,
part.
we are not
Yes,
finding fault with you that you are not
No, no,
personally
no.
present. But we are not seeing any progress.
Lord, I can assure your lordships, Lord, in last few days, Lord, much progress has been made. It's not that, Lord, and the authorities are also taking, Lord, monitoring the situation. Lord, we have also requested what has happened, Lord. Some maintenance works we had started, Lord, in this because of the rainy season and all, Lord, and your lordship has highlighted
See,
because of
rainy
this.
season, this season, that season,
Lord,
these are not new things.
no,
These are
Lord,
in
that's
your estimate. Do you know
my
that
Lord.
from this,
Yes, yes, yes.
this,
It is
this,
the scope of
this
our
period,
work,
there will
Lord.
be rains.
Maintenance part is also
There
there,
will be a
Lord.
halt. And therefore, the tenure is fixed, that within this tenure, this has to be done.
Lord, we have also coordinated with the district administration, Milord, regarding diversion of, and in fact, in one section, Milord, the route has been diverted, Milord, and in respect of two, Milord, there is a site visit program, Milord, so that, Milord, things can be expedited on that front, Milord. These are the works in progress, Milord. I can assure your lordships on the next day, Milord, when your lordships
No,
take
your
up this.
assurance without, I don't think you have got instructions to assure.
No, Milord, I have
You are
instructions.
just
That's
making
why
an assurance on your own.
No, Milord. On
As an
instructions,
officer.
Milord. No, Milord. On instructions, I have indicated your lordship.
What is the list of labor, the
My
manpower?
lord, they have given a list. The labor number is 115. There are 5 excavators, 6 dumpers, 2 graders, soil compactor 2, 1 JCB, 2 pavers, 2 tandem rollers.
Milord, in our status report, we have annexed that, Milord.
Yes, Mr. Ratan, what was the requirement of regarding list of equipments and list of manpower, technical personnel in the contract? Are they adhering to that? For a work of this magnitude, will this be enough?
I will take instruction.
No, what was the original requirement as per the contract? In the bid document, definitely there will be a
Yes, yes.
requirement that you must be equipped with this much of
Yes, yes.
equipments, machineries, this much of manpower, this much of technical personnel.
Yes.
Apparently, this is not sufficient for work of this magnitude.
Yes, that I will take instructions. What's the actual?
No, things, doesn't appear that you have taken things seriously. You are inviting some drastic orders from the court. We won't mind passing drastic orders.
After on this honorable court's last order, then only on the night of 19th, my lord, they did this patch of work. Nothing else, my lord, no.
We may also initiate a high-level inquiry, CBI inquiry. Why this is going on? Who is involved? Why this delay? How the work will be given without a list of list of workforce, list of equipments,
And one more thing I will point out, my lord.
and this list, if it is correctly pointed out, Mr.
Yes, it is
Baipangi,
their affidavit.
which you do not doubt, this will be wholly inadequate. How can this be adequate
Yes.
for a work of this
It is
magnitude?
their affidavit, my lord.
Status report of the.
And one more thing I will point out, my lord, this principal contractor that Mr. Dubey is representing, he is not doing anything. The flyover has been subcontracted to somebody else. TK has been given something, my lord. I don't know what he is doing. This is something I've been pointing out all the time before this honorable court. What is the
Sub-
principal contractor doing?
Subcontract is a part of the contract. Is it
Yes,
allowed?
up to 49%.
49%. Now, if it is done in accordance with law,
then
we
we
don't have
understand.
much to comment. Our concern is
Yes.
the completion of the work with quality maintained.
And that is why I'm making this prayer. At least, my lord, from model village to Nirduli part, my lord, they should start in right earnest, my lord.
What is the value of the contract?
It's more than 4,050, just a moment. 450, my lord, more than 450.
Around 496 crore.
Yes, my lord.
And this is the equipment and manpower.
4391.55 lakhs.
And this is the total equipments.
Yes.
115 laborers.
Hmm.
1 JCB.
That's what, that's I was pointing out, my lord. One JCB will, my lord, dig up the mud, my lord. And these 11, 12 laborers will by hand, they will be binding. That is what is going on.
Mr. Dubey, you are so poor. You are those,
No, no, my lord,
you have
no.
only one JCB.
No, it's
You are
not,
doing
my
a
lord.
400 crore, 500 crore contract. How is it possible?
No, we have sufficient manpower and
No,
machinery.
where is the?
No,
in the
no,
list-
Mr.
in the
Dubey,
list
please
of-
don't submit
in the
like
list
that.
of, equipments, where is the number of the CB? One.
Well, my lord, he's from the contractor side, he want to add something.
He has got his counsel. Why should we hear him? Is he being summoned to the
My
court?
lord, no, I'm not.
If he has come to the court on his own volition, at best he can hear, nothing more than that. If we want,
sir.
we'll take his.
My lord, on
Versus-
next date, my lord, we'll all provide your lordships the details, whatever we are having, my lord, and
But,
what we are deploying your
things are
lordships
not
on
in
this.
the right perspective, Mr.
But
Dubey.
I understand, my lord, there has been
We
difficulties.
did not say more than this.
My
We can
lord,
say many things. It can go on, but simply wasted of time. We are more interested in the work.
my lord.
But it's a matter of astonishment that there is not a single work. The area where Hatimata is there,
Yes,
what we are seeing for the last 1 year is the same.
yes, my lord, exactly.
Not a single improvement, no progress. Some pillars have been erected,
Yes.
thereafter nothing.
Yes,
They have not even maintained the road.
that is after this PIL was filed, my lord.
They have not even maintained the road.
Absolutely, my lord.
Go by a small vehicle, you see you have the experience.
Can't think of the pedestrians, my lord. It's impossible to walk there.
Status of the progress for this part and fix it over 15 days. And also last week I told us we instruct the progress of the last week I told us what were the requirement of the contract regarding the basis of recruitment and power director as a control. Yes.
Okay, what to do now? Tell us. You should be the one who should be the most concerned.
Yes,
Project is of the state.
yes. Now, what my instruction from since Kato is not there, what he wants to say is that instead of temporarily maintaining the road, they are going for permanent solution. Therefore, the construction of drain, they are starting and retaining wall.
Since when? When will it start?
Last
Since-
2 weeks, sir. Already started, sir, last 2 weeks, sir. Drain has been completed 1,050 meters. Because before.
Oh, you have started the.
Yes, sir. Then, but before going to the permanent solution. the
See,
first we
but
have
for
fixed
this
the-
kind of mechanism, we don't have anything to comment. They are the best judge how to address the solution, the problem. And we want early completion with quality maintained. They should do it. But we are not finding anything that has been done.
Since this last 2-3 days, they have started this. Let's wait for this another 15 days on the next date. Let's see whether there is any substantial.
But why was the court's order necessary to have it
Yes.
started from last 3 days? Is it the duty of the court, job of the court to oversee works of roads? This is not a part of the judicial proceeding at all. Why should these matters come to the court? Why should a citizen be forced to come to the court for matters of this nature? Pursuant to the order dated 8/5/2025, both the respondent number
6 and 7.
6,
6 and 7.
which is the Ministry of Road Transport and Highways, as well as the respondent number 7, the concerned contractor, have submitted status report on the progress. Full stop. Apart from progress, full stop. We have heard through the learned counsel for the petitioner. We have also heard Sri N. Ratan, learned AAG. Full stop. The Ministry of Road Transport is represented by your name, Sri so-and-so, who has appeared on instruction of Sri M. Kato, the learned deputy AGI, who is stated to be indisposed. Full stop. Sri Subhash Chandra, Regional Officer MORTH, who is present in the court, has also addressed on the issue. Para? This court has been informed that from
19th.
Tuesday
Yes,
or
19th.
Monday,
19th.
Monday, from
Monday.
from 19th, there is the departments, the respondent departments have taken some major steps of diverting traffic so as to enable the work to progress. The Sri Panging has, however, pointed out that apart from the area where there appears to be some kind of encumbrance, and not a total encumbrance, some kind of difficulty in execution, there is an area from Model Village
To Nirjul.
to Nirjuli, which is apparently without any hindrance, but no work is progressing. Full stop. We have also produced from the status report the list of equipments and manpower, both manpower including technical. Do you have a good and manpower, which appears to be grossly inadequate vis-a-vis the magnitude of the work. Full stop. On a point, on a specific query made by this court, the learned counsel for the respondents are not readily equipped with the instructions as to what was the requirement of the contract in this aspect. Full stop. Para. Considering the above, the matter is adjourned to be listed. Adjourned,
Yes.
listed on,
But there is already, by this order, H5, my lord, series of days have already.
listed, adjourned to be listed as per the schedule already indicated in the last order. In the next, on the next date, the department is to furnish the information regarding the requirement, regarding the specific requirement under the contract of the equipments and the workforce, including technical personnel. Sri Dubey, learned counsel, who has appeared online for the respond number 7, has assured on instruction that in the meantime, work for the portion from Model Village to Nirjuli would also be taken up in the right earnest. By the next date, status of the progress achieved for that portion is also to be furnished to the court. Full stop. Where? Sri Chandra, the regional officer, has informed that so far as the maintenance part is concerned, a decision has been taken to do it on a permanent basis. And in this regard, certain works have also progressed, including work of drainage. Full stop. The progress of the said work may also be indicated in the status report to be filed before the next date. List on
Yeah, that is already given, my
five,
lord.
six,
That next date would be, my lord, 4/6.
4/6. 4/6 or 5/6? 5/6.
There's already a schedule given in the earlier order.
4/6. No, 4/6.
4/6, my lord.
4/6.
5/6. No. So no, 5/6. This 4/6 progress report,
Oh, sorry.
On 5/6.
Yeah, 5/6, sorry.
which has already been indicated in the earlier order. The status report submitted today by the respondent 6 and 7 are kept with the records. Okay.
Deep.
Please, your lordship. In order not to waste the time of this honorable court, may I make a submission, lordship?
Yes, please.
I am in this case, I am for the respondents, private respondents 1 to 33. The appeal today is of course for the IA, but the appeal itself has been filed on limited grounds, only to a certain extent. If the prayer in the appeal, the relief they are seeking is only to that ground, then we are conceding.
But, they have already filed a contempt petition also to infringement of this order, my lord.
No, that will have to change, of course, later.
No, Ms. Dangan is saying that they are conceding to your prayer, which is there in the petition.
Yes, my lord. That is
If there is such a concession, there is no point having this
Yes, Lord.
pending. We can close this.
Frankly, we don't have money to go to the apex court if anything happens. They will go, we won't have money to go.
Apex Court have legal aids.
Yes, we tried that also. In other cases, we tried. Its experience has not been very good.
What are you saying? Now it's very proactive.
So if we win this case, they will certainly go, which we won't have money for. If we lose the case, we won't be able to go. So since they are making a limited, asking for a limited relief,
What
we
is
are
the
ready to
relief
concede.
you are asking? What is the
That
relief in
is-
this relief?
Yes, ma'am. That is in page number 33.
What is the subject matter?
I'm saying the land compensation, my lord.
Land compensation.
Yes.
What was the order of the?
Order of the court is, my lord, page number 249. that
What
is-
was ordered?
That was, my lord, may I read the order? That is, my lord, regarding the interest part. The honorable court directed to give the interest part from 2009, that is from the date of notification, my
Yes.
lord. But
In-
that notification was.
You are challenging the interest part.
Interest part, yes.
What
ma'am.
is your relief you are seeking now?
My lord, that is, as per our relief is, my lord, that is to set aside the clause, the order dated 14/5 to pass by the landed single judge so and so to extent of directing the deputy court to examine the question of interest amount since the year 2009, because the dispute is on 2009, my lord.
Now, what is your, what do you want from the court?
My
You
lord,
want that the interest part from 2009 should not be awarded.
yeah, should not be awarded.
So,
It is.
are you exceeding to any interest from any other period?
No, my lord.
No interest altogether.
2009, my lord.
No interest.
No interest. We are being given rent.
And the compensation has already been paid, my lord. 100% compensation has already been paid.
Hello. They're considering the report is complete. Yes, Mr. Nawam for the state
Yes, my lord.
and Madam for. Okay. The Union of India has some role in this matter.
My lord, I have on behalf of Union of India, I have.
No, she is for whom?
What's it?
No, that we know.
There cannot be two stating council for central
No,
government.
there can be.
Yes.
There can be more than two, but they cannot appear together.
Yes.
I remember once Supreme Court said, my lord, how can my lord two stating council represent one union government, my lord?
There is no concept of sitting council.
My lord.
So they have to stand.
They have to stand.
No, but how are you a respondent here, madam?
And you are referring 1 to 10.
1, 2? Who's the appellant here?
Appellant is
Union of India.
Union of India.
Then
1
who's the
to 10,
respondent number 1 to 10?
1 to 10.
Then who's left?
Who is 1 to 10?
There is no 1 to 10. Are you sure?
One is no, one is the private respondent, 1 to 10.
Hmm?
1 to 10 are the private respondents, my lord. 1 to yes. 1 to 33, all are private respondents, my lord.
No, where is your memo of appeal, madam? Writ appeal. Where are your area of parties? Why do you write the entire writ petition
Yes.
parties here?
I have already filed my
Union of
memo.
India Secretary, Principal Director.
Hmm.
1 to 10, madam, you cannot appear for 1 to 10. 1 to 10 are private respondents, where Madam Dangan is appearing. In fact,
1 to
1 to
33.
33, all-
33, my lord. All are private respondents, my lord.
you should come here with your senior colleague and sit beside her.
ये इसको बोल रहा है.
Hmm,
Okay,
hmm.
we can dispose this of them.
There's some direction also regarding the contempt case, my lord. They have
No,
already
that
filed.
will become instructions. We'll have to file a new one. The
Okay.
contempt,
Contempt is for what?
contempt was for the, it was,
But you have already been paid the compensation.
Yes, my lord.
If you're foregoing your right.
no,
for
no,
the
no,
interest-
Lordship. The order is in two parts. This order that they are challenging. First, the rent. Secondly, the interest from, with effect from 2009.
Okay, rent part is not. the
Rent
subject
part is,
matter-
yes.
Is not the subject matter of challenge here.
Yes, that is not in the prayer. The relief they've sought for is only with regard to the extent of the interest.
Seeding is there, but in the prayer portion, that 10 part is not the prayer portion, my lord.
If it is, if they are praying only for this, then that is what I'm saying. We are conceding to that. But
Yes, yes.
My
what-
lord, regarding the rent part, my lord, if they, my lord, in our ground number 5, that is page number. Sorry, page number 31, my lord.
Satisfied.
Page number 13, our submission on,
To the extent of directing to examine the question of interest, it is
Yeah.
very specific.
yes,
Yes, ma'am.
Lordship.
That
You
is
cannot
in-
reopen the rent part here.
yes.
You
yes,
cannot. Heard Miss Egan, the learned CGC, who has appeared for the appellant. Also heard Miss Ann Duncan, learned counsel, for the respondent numbers 1 to 33.
33, 1 to 33.
You are not there. It is not a party in the appeal. Okay. The present appeal,
38 to 43. 38 to
30,
43.
38,
41, 42 and 43.
okay.
38 to
Oh, there are, oh, yes, yes.
yes, there is.
She may have a
Yes,
case.
34 to 37.
yes.
34 to 37. ma'am.
Miss, what is your name? Keche. Learned counsel, appearing on instruction of Sri M. Kato, Deputy AGI, is present for respondent 34, 35, 36, and 37, whereas Sri R.H. Nabam, the learned AG, is present for the state respondents. Number 38 to
43.
43.
43. Better? The instant appeal arises. No, this intra-court appeal has been preferred against. No, not so, don't say against, in connection with a judgment and order dated 14/5/2024 passed by the learned single judge in WPC 97 AP 2021 Full stop. Full stop. For better appreciation of the objective and reasons for which the appeal has been filed, the relief sought for is extracted herein below, page 33. Okay. Full stop. The impugned judgment was in connection with payment of compensation.
Payment of rent and interest.
Huh?
The compensation we already
Compensation
received,
only
past
of
rent.
rent.
Payment of rent and
Inter-
also for interest after its determination in connection with acquisition of land. Full stop. It appears that it is not in dispute that so far as the compensation is concerned, the same has already been paid. And the instant petition was only for the aforesaid two purposes. Full stop. The learned single judge, while the impugned judgment had allowed the writ petition on both the counts, and as it appears from the relief sought for, the present challenge is only to the extent of examination of the question of interest since the year 2009 and to take consequential steps thereafter. Full stop. Ms. Gayan, the learned counsel, has submitted that payment of interest is not envisaged by the statute and therefore the said direction is not in accordance with law. Full stop. On the other hand, Ms. Dungan, the learned counsel for the private respondents / writ petitioners, has refuted the aforesaid proposition and has contended that such direction is in consonance with law, as a huge amount of money was withheld without any authority of law. Full stop. She has, however, submitted that as per instructions, she would not oppose the present prayer, only to bring the litigation to a logical conclusion. Full stop. She has very candidly submitted that her clients are not in a position to continue with the litigations in future. Full stop. Sri R.H. Nabam, learned AG, as well as Ms. Swenson, learned counsel for the respondent number Swenson, have submitted that in view of the aforesaid concession made by the affected parties, the appeal may be closed. Full stop. Para. After hearing the learned counsel for the parties and on recording the concession made by Ms. Dungan on instruction, we are of the opinion that there is no reason to keep this appeal pending, and accordingly, the same is allowed. Full stop. It is, however, made clear that the present order pertains to only the aspect of
Interest.
the determination of the interest from the year 2009 and consequential action thereafter, and not on the other aspect pertaining the rent.
Yes,
Full stop.
obliged.
Appeal accordingly stands disposed of. Okay, we'll come in 10 minutes.
Yes, I beg to miss item number 18, my lord.
Hmm.
My lord, with consent of other side, my lord, I am praying for listing the matter after checking, my lord. I am yet to file a affidavit in reply, my lord, to the affidavit opposition filed by the state respondent.
When was the affidavit in opposition filed?
Sometime back, my lord.
Just filed some time back. But file it within this time, okay?
My lord.
On a prayer made by Sri L. Permi Learned Counsel for the petitioner. Matter is adjourned by 3 weeks to enable him to file rejoinder affidavit. Miss P. Pangu Learned State Council is present. Yes. Is there an interim order pending? No.
No, my lord.
Okay, next.
My lord, item number 16, my lord. So, my lord.
Yes.
Here, last occasion, my lord, I was directed to take dusty service upon the private respondent number 3, my lord. I did do all the necessary step, my lord, to route it to the registry, my lord. But I could not materialize, my lord, could not serve due to miscommunication with the petitioner, my lord. So I am praying, my lord, this time, my lord, I'll take
But
dusty.
what about the date? In a dusty, a date is given to enable the respondent to appear on the said date.
Yes, my lord.
If he's
The
not
date,
aware-
my lord, this time I'll give me dusty service again, my lord, so that I can take
I don't know. Let the matter reach. We'll see the earlier order.
my lord.
Three L permit. Okay. Let it counsel for the petitioner has submitted that though there was a direction to cause dusty service upon the respondent number
3, my lord.
3. He submits that though 3 for do vision, 3. He submits that those steps were taken, though the preparation was made, but the notice could not be served. Full stop. He accordingly prays for certain extension of time. Para? In view of the above, let a fresh notice be issued to the respondent number 3 by Dusty, wherein the next date is to be clearly reflected. Full stop. The notice is to be issued by the registry, in which giving the next date, which is fixed on was fixed on 11th of June. 11th of June. Full stop. Prior to the next date fixed, the learned counsel for the petitioner is required to file an affidavit in proof of such justice service.
And here interim orders there.
There are interim order passed earlier to continue till the next date of listing.
I love you.
My lord, I beg to mention item number 29.
29, yes.
Yes,
please.
madam. I have taken consent.
Yes.
My lord, may kindly give fixed date on 13th.
On adjournment.
Yes,
On
yes.
behalf of whom?
Yes, I am.
Petitioner.
Yes, you know, petitioner.
Hearing matter.
Yes, madam.
What is the matter about?
Please, my lord, challenging the order.
You have to challenge an order. What is the subject matter? Saying that will be not enough.
Allotment, my lord, land allotment.
You are not in this matter. Your name is there or not?
There is, yes.
Then why don't you know about the facts?
Actually, my lord, leading counsel is out of
It
station.
is not a question of leading counsel. If you are there on record, if you are not there on record, if you are come to mention, you should know the facts, the basic facts. Not all the pages, the intricate problems, no.
Yes,
What
my
is
lord.
the case about? You should know.
Yes, my lord, actually the deputy commissioner have first an order in favor of petitioner. And-
Petitioner.
Yes, my lord, and finally suppress that final order. So challenging the order.
Petitioner, why are you challenging? It is given in your favor. If the deputy commissioner has passed an order in your favor, why are you challenging?
Then after, upon application from the respondent, he suppressed this final judgment.
Madam? Eviction, you
Yes.
should tell us that. Okay. What is your name?
N. Karga, my lord.
On a prayer made by Sri N. Karga, learned counsel for the petitioner. Matter is adjourned by 2 weeks.
Yes.
Miss Basar, R. Basar, learned state council is present. Is there an interim order?
No, my lord.
Yes.
Obliged.
Yes, madam.
Lordship, as instructed and on behalf of M.
Which
Kato,
matter? Item number
item number 10.
10.
Yes, Lordship.
What is your prayer?
Lordship, adjournment and fix it
Adjournment.
on
Yes,
Tuesday.
government council, have you informed?
We have taken consent.
What is your name? Are you on record?
No, Lordship.
Miss
Yasmin.
so-and-so, learned council has prayed for an adjournment on behalf of Sri M. Kato, learned counsel for the petitioner.
Petitioner.
Para. Also heard Miss P. Pangu, learned state council. Para. Matter is accordingly adjourned by 2 weeks.
No, Lordship, fix it on Tuesday. Coming Tuesday.
Why? Tuesday is auspicious or what?
No, Lordship, last time also, Mr. Kato, tried to dispose the matter, but due to,
Today he should have been there, we would have disposed it of.
no, Lordship, due to personal difficulty, he is not here.
Tuesday court will have personal difficulty. It cannot be the choice of the council.
Sir, Lordship, he have,
For a week. 1 week. Yes.
and
Is
Lordship,
there an interim order?
no.
Okay.
And Lordship, another item number 23.
23.
Yes, Lordship.
Yes.
We have taken consent from the petitioner.
You are for the respondent?
Yes, Lordship.
Yes. What do you want?
Adjournment. And
Adjournment. On a
Lordship may
request-
kindly fix the matter on,
On a request made by Ms. So-and-so, learned counsel, on instruction of Sri M. Kato, learned counsel for the respondent, matter is adjourned by 2 weeks. Have you filed affidavit?
no, Lordship, we will file affidavit.
Matter is adjourned by 4 weeks to enable filing of affidavit in opposition.
Obliged.
May I, lordship, I beg to mention item number 24, your lordship,
Hmm.
on behalf of JG, it is a hearing matter, your lordship.
Not
He's a-
hearing, admission.
Admission hearing, yes. He's out of his station, your lordship.
Ginny is
So-
out of station.
Yes.
Inform the other side.
Yes, inform the other side, your lordship.
A request has been made on behalf of Sri J. Ginny, learned counsel for the petitioner for adjournment. Tara? Tarak is there in the court?
Yes.
Sri, also heard Sri G. Tarak, learned standing counsel, as well as Sri B. Picha. Picha is there?
Yes, yes. He was there, your lordship.
Picha.
I informed him.
Okay. Tara, accordingly, list this case after 2 weeks.
Can it be listed on 2nd of June, your lordship? As instructed, your lordship.
List in the first week of June.
Okay, lordship. Oblige, your lordship.
Yes,
Your Lordship, I'd like to mention item number 21.
21 years.
Due to sudden demise of his maternal aunt, the leading counsel is out of station, Your Lordship.
Who's the counsel?
Tanya Kipa.
Okay. This court has been informed that Sri T. Kipa, learned counsel, has suffered a sudden bereavement and therefore adjournment has been sought for. Para, list after 2 weeks.
4 weeks, Your Honor, Your Lordship. And,
List after 3 weeks.
Your Lordship,
Is there any interim order?
no. Respondent number 6 is private. So we may pray to reserve again through the ST. Right. Respondent number 6 is private respondent.
Then you have to. What is your name?
Ketana.
Ketana, you are not on record?
No.
Okay, then cancel the order, huh? Sri Ketana, learned counsel, appearing on instruction of Sri T. Kipa, learned counsel for the petitioners, has informed that the counsel on record has suffered a sudden bereavement and therefore an adjournment has been sought for. He has also made a prayer to allow serving of notice upon the respondent number 6 by Dusty, full stop. Para. While this matter is adjourned by 3 weeks, the petitioners are granted permission to serve dusty notice upon the respondent number 6, which however is required to be routed through the registry of this court. Let the next date be fixed on 16th of June 2025, and in the notice accompanying the dusty, the next date is to be clearly reflected. Prior to the next date, an affidavit is also required to be filed by the petitioners in proof of such dusty service. Okay. 16th is the date, okay?
Highly obliged.
Yeah, my lord. I beg to mention item number 28 for 3 weeks adjournment.
28, you want to hear for whom?
Petitioner.
Mr. Tagum?
On behalf of Entaje.
Tagum has been informed.
Yes.
A request for adjournment has been made on behalf of Sri N. Taji, learned counsel for the petitioner. Para. List after 2 weeks,
3 weeks, sir.
22 matter, 2 weeks.
Okay.
2 weeks, yes.
May Lordship. Lordship, I beg to mention item number 6,
Yes.
7, 8, and 9. On behalf of
Connected.
Senior Standing Counsel, Tita Tabatagum, Department of Education, Lordship.
T. Tagum.
Yes, Lordship.
Okay, he has some difficulty.
Yes, Lordship.
Okay, even from the other side.
Yes, Lordship.
6, 7, 8, 9, huh? Say connected. A request has been made on behalf of Sri T. Tagum, learned standing counsel, education for adjournment on personal grounds. Full stop. Para. The matters according to stand adjourned by 2 weeks.
3 weeks, Lordship.
So have you filed affidavit?
Yes, Lordship.
Why 3 weeks? 3 weeks is a long time. 2 weeks. Yes.
Lordship. And
Is there any interim order pending?
no, Lordship.
Operating? No. Yes.
Lordship, item number 12 also.
Yes. Same.
Yes.
Same.
Lordship. Yes, Lordship.
Okay.
Item
Madam,
number 12, I am the petitioner. There is an interim, your lordship.
12 same order. Interim order passed earlier to continue till the next date of listing. Your name, madam?
M. Sora.
M. Sura.
Yes.
M. Sura. Record Puriva is present for the petitioner who informs that there is an interim order pending. Absolutely.
And also, Lordship, 13, item number 13 also.
13.
Yes,
13
Lordship.
to first order. 2 weeks at interim line.
And Lordship,
What is your name?
Titato.
Tita to dekhi devo sabode.
And
You're on record or not? You're not on record.
yes, Lordship.
Naam to likhe lo.
And
Yes.
one more, Lordship, item number 20. Item number 20 here, we are for the health department, Lordship.
Okay. Agot kira heri asil, education asil. Etu hol, 20 hol, health department. Other side informed.
Yes, Lordship.
Ever naam likhiba, huh? On behalf of T. Tagum. T. Tagum, huh? SC Health. 2 weeks. 2 weeks, yes.
Your lordship, I'm there for the petitioner.
Yes.
In item number 20.
Okay. Ye
I was
Bhattacharya ji.
Not informed, your lordship.
Not informed.
Yes,
You said you have informed. He is in a different case, he's a different council. Informing some council will not mean informing him.
Oh, pardon, Lordship.
You should inform, don't make. You're having a very healthy practice of informing. We take this bar as an example, even in principal state, we say that Arunachal is having a very healthy practice without informing, no mention. Okay. Sri A. Bhattacharya. Okay, we are adjourning for 2 weeks. A. Bhattacharya, learned counsel for the petitioner is present. Petitioners present, okay. Is there any interim order?
No, lordship.
Yeah, my lord. My lord, I beg to mention item number 4.
4.
Yes, my lord.
Yes.
My lord, I'm appearing on behalf of leading counsel Esther
My lord, matter may be released after 4 weeks. In the meantime, he will file an affidavit, my lord.
You have not filed affidavit?
Not yet.
Four.
Yes.
You have for four, lawyer?
For the petitioner, Lordship.
Okay, they're asking for time to
Long
file
pending
affidavit.
matter, Lordship.
Long pending, 22. We'll not grant 4 weeks.
Short date, maybe.
We'll give, grant 3 weeks time, but file it within 3 weeks. 22 matter, we're not going to adjourn.
Even
And
Lordship,
22
3 weeks is
matter,
Very long, Lordship. 3 weeks
pleadings,
is-
should have been exchanged. We should not wait till 2025.
Even Lordship, 3 weeks is very long, Lordship.
What is the subject matter?
See, here, Lordship, petitioner is challenging the appeal proceeding which is pending before the Deputy Commissioner of Pasighat.
Okay, 2 weeks.
Okay, my lord.
Heard speak K lawyer learned counsel for the petitioner. Full stop. Also heard Sri
Deem my lord.
so learned counsel appearing on instruction of Sri S. Tai. For the respond number?
4.
4. Full stop. Sri Y. Ram learned standing counsel, learned state counsel is also present. Para? Sri so has, however, prayed for some time to file affidavit in opposition. Full stop. Para, considering that this petition is of the year 2022, 2 weeks time is granted to file affidavit. 2 weeks. File it in 2 weeks. Otherwise, we'll go for admission hearing.
The interim order is there. Let me be.
There are interim order passed earlier to continue till the next date of listing.
Obliged.
Mr. Patil, what is this?
But on the last occasion, but this court has put some queries. But I have filed my additional affidavit. In my additional affidavit, my lord, I have annexed that copy of the judgment on the execution petition. My lord, this totally reveals that this was filed as per the provisions of law. This execution petition was filed under section 36 of the CPC. And after
Yes, madam, copies out upon you.
Yes.
you should notice maybe.
You want this matter to be addressed today or some other day?
But only for notice to be issued, my lord.
No, notice. But this, we have read the order passed by Justice Surana. It's a elaborate order.
Yes.
Requiring you to satisfy the convince the court on certain points. According to which we have filed the additional affidavit. We have cursory gone through the additional affidavit. Have you gone through the additional affidavit?
Yes, Your Lordship. Your
What-
Lordship, as per the earlier court's order, Your Lordship, we have executed the process, Your Lordship. Eviction has been done, Your Lordship, and compliance report has been submitted, Your Lordship, to the registry, Your Lordship.
No, it is not on that. The court was confronted with some issues on the aspect of issuing notice even.
Lordship.
And therefore, the direction was given that an additional affidavit would be filed. And with a particular observation that the issue would be addressed by the learned counsel for the petitioner on the next date. Mr. Patil is ready to address on the basis of the additional affidavit filed. Have you gone through the additional affidavit?
Yes, Lordship.
We'll require your response.
Lordship.
Yes, what is this? What is this?
Well, the basic query was whether the execution petition could have been transferred and then was re-registered, or the deputy commissioner is a designated civil court. My whole submission is that the execution petition was filed before the competent authority, and it was filed under
Now,
the
after
provisions.
separation of the judiciary, where is the deputy commissioner's role in a judicial proceeding?
No, my lord, that order only for physical education, for that purpose only, it was the DC, deputy commissioner was directed to cause the physical eviction as per the decree passed by the court.
Okay, decree was passed by a court.
Court, yes.
The execution part was left to the deputy commissioner.
My lord, there was a title suit. In 2007, decree, judgment and decree was passed.
You are the plaintiff.
I am the, yes, I am the
Plaintiff.
plaintiff and judgment holder. And my lord, it was
You are a decree holder.
decree
plaintiff.
holder. I am the, it was found that the respondents, defendants were occupying our lane
Okay.
illegally.
Okay.
And therefore, it was directed that the land should be vacated. Vacated
Vacated and this peaceful possession be returned to you.
to return
You
to
have
me.
prayed for recovery of possession also.
Yes,
Okay,
and
then
that was not,
decreed.
they appealed various writ petitions, regular first appeal,
All lost.
all dismissed. And this judgment and decree stands its footing
Yes.
till date.
Yes.
Now, my lord, when it was not implemented, then we had filed an execution petition under section 36 of the CPC.
Okay.
And that was taken up. It was taken up, and then notice were issued, respondents appeared, proper written statement submitted,
Objection.
heard,
Yes.
and lot of issues were raised by the respondents also. So that was all addressed. So therefore, my lord, by this annexure 1 in my additional affidavit, on 14 July 2014, the Court of the Additional District Session Judge, Basar, passed this order judgment. And it was held again that the judgment debtors are required to be evicted and physical possession.
But the court has come to a tentative finding that your initial execution case had spent its force without there being a fresh petition for execution. Can the earlier petition be revived? And if it revives, and so far as filing of a new petition is concerned, the aspect of Article 126 of the Limitation Act would come in.
No, my lord, we are not intending to file a fresh execution petition because there is no provisions at all for filing second execution
But
petition.
what about 26/8/22 order by the Deputy Commissioner, where he has said that the execution was carried out?
Therefore, my lord, in our writ petitions, earlier also, in our writ petitions, our stand is that it
Okay,
was,
okay, we'll issue notice at this stage.
Yes.
Okay. Third, Sri T. Patil, Learned Counsel for the petitioner, one petitioner,
yes, the representative capacity.
petitioner. The matter relates to certain directions, to a decree passed by the civil court in favor of the petitioner, who was the plaintiff.
In
And in this connection, the petitioner had earlier approached this court in WPC 141 of 2021, in which this court had passed an order dated 15/5/2022 directing for carrying out the execution proceedings.
And to hand over the vacant position.
Execution proceeding. The aforesaid direction has not been complied with and complied with except for exchange of certain communications. Para? When this matter was taken up by this court on 8/4/2025, the petitioner was directed to file an additional affidavit on the aspect of the earlier execution petition. In pursuance to the said direction, the petitioner has filed an additional affidavit on 21/5/2025. And reparting the learned counsel has addressed this court on the aforesaid aspect. Para?
This is an education issue between the private parties. Here, the chief secretary has been completed this part. How is he can consider the deputy commissioner, even if in educating, as a educating court, what cannot be implemented? And ADC and superintendent of police law, how they are. This is a purely education.
They can raise this issue, there is this now.
What's the para? Sri S. Tapin, learned senior advocate, AP.
The private
Why-
party are not the party here. Even not, they are not implemented.
They're not parties.
Wait,
Private party?
not at this model.
Why?
This is the, how it can be executed before this one.
Learned senior has however pointed out that the writ proceeding is not even maintainable in absence of the private party who was a defendant in the suit and against whom the execution proceeding would be conducted. Full stop. He has also raised objection regarding regarding misjoinder of parties in as much as the chief secretary or the deputy commissioner whereby misjoinder of parties whereby the chief secretary, deputy commissioner, SP have been and additional deputy commissioner have been unnecessarily made parties. Full stop. Para. While the aspect of misjoinder can be taken up at a later stage, the aspect of non-joinder is
I may be given liberty to.
Is- a major issue, as in absence of the concerned party who was the defendant in the original proceedings, the present petition itself cannot proceed. Full stop. Para. At this stage, three party, the learned council.
Maybe given Malat, the only respondent number 5 maybe can be added in.
No, not by hand. CIS is the
Okay.
learned council prays for a liberty to file appropriate application for implement of necessary parties. Full stop. Para. Accordingly, the matter is adjourned by 2 weeks to enable filing of such interlocutory application as may be advised.
Obliged.
That's for lawsuit, additions of the necessary party law. But in deletions of this.
Deletion, we have already, we have said we'll consider it.
No.
DC will be necessary party because direction.
We have
must
not
be-
said anything. Therefore, we have said we'll consider the appropriate seats. Madam, your name should be recorded now.
No.
For whom?
No, we don't.
May I please, your lordship.
Yes, Mr. Sharma.
Lordship, matter pertains to recovery of excess payment from a retired employee, Lordship. He is a state government employee working under the respondent number 3. And
What?
after his retirement, your
Retirement as
Lordship will
what?
find,
Retirement as,
Lordship, he retired on,
as what?
Lordship,
Retired as what? What post?
retired on 31st one,
As
retired as LDC, Lordship, a grade 3 employee, Lordship.
grade 3.
Yes, your lordship. Your lordship will find at page number 54. The first communication that was made by the respondent number 2 to respondent number 3. That was on 21st March 2024 after the retirement of the petitioner, lordship.
Anything has already been recovered.
Yes, lordship.
Recovered-
The amount which has been recovered, your lordship will find at lordship page number 56 and page number 58. in
Already
his-
recovered.
Already recovered,
Now,
lordship.
will there be a further recovery? Is there any aspect of further recovery?
Lordship, no further recovery, lordship. The
Okay,
amount
then
which
we
has
have-
been recovered, lordship, that the process which has been opted by the respondent authorities, that was completely arbitrary and it is.
Mr. Sharma, we are not on that. We are on the aspect of whether you are also praying for any interim order. If
No,
there-
I am not praying
Then
for
we
any
issue
interim.
notice there.
Yes, your lordship.
First, Sri D. Sharma, learned counsel for the petitioner, who has approached this court by the action of the respondent authorities in making recovery from his pensionary benefit. Full stop. It is submitted that the petitioner had retired from service on 31/1/2024 as an lower division clerk from the Public Works Department.
Yes, Your Lordship.
He has submitted that the petitioner had got his MACP financial upgradation and also the revised pay in accordance with rules. And during his service tenure, there was no objection of any nature. Full stop. He has also submitted that law is well settled in this regard and has referred to the case of Rafiq Masjid.
Yes, Your Lordship.
Whitewash shirt, huh?
That
Versus
is state of-
so-and-so, reported in so-and-so. Huh? Give the citation. Para? He has informed that by this time, the recovery has already been made. Para, let notice be issued, returnable by, madam,
4 weeks, Madam.
4 weeks. Yeah, for all the respondents,
All the respondents.
Ms. So-and-so, London State Council. Accept notice on behalf of all the respondents. Let extra copies be served upon her by tomorrow.
Yes. Highly obliged.
These matters are well settled. We'll try to dispose of on the admission stage, okay? Only, madam, one thing you have to ascertain, whether in this calculation, which the petitioner is alleging to be erroneous, whether he had any role in this calculation. Otherwise, he's a grade 3 employee. Traffic machinery will come into operation. Yes. Yes,
May I, my lord?
item number
3.
3, yes.
My lord, this matter pertains to the cancellation of my appointment order.
Cancellation.
Yes, my lord.
Appointment as
Appointment as casual labor.
casual labor. Which order?
Order is on
Page?
page number 15, annexure B, my lord.
1/5.
Yeah, 1/5. Yes, my lord.
Please read.
In the interest of public service as approval of the SE Electrical, APEC, Department of Power 0, white computer number, this may be noted, 2228818, Sri Gyamar Nimpu, son of so-and-so.
Now, this is your appointment. Where is
Yeah.
your cancellation?
Cancellation order is on annexure D, page 17, 17. May I read, my lord? In cognizance of order number so-and-so, the casual appointment carried out in the approval of SE, order number 228818, file number so-and-so. As per the sanction stand are as follows.
27/3. Okay, we'll issue notice. Yes. Why was the cancellation made?
Notice mail, I have no email.
Okay, well, yes, sir. You've got some instructions.
Yes, madam.
What is it?
I wasn't, my lord, informed of this cancellation also, and no notice or any correspondence was made to me.
Heard your name, please.
Alu Kamsar.
Learned counsel for the petitioner, who is aggrieved by cancellation of his appointment as unskilled casual labor. Full stop. It is the case of the petitioner that on 7/3/2025, he was appointed in the said capacity by an order passed by the executive engineer within bracket E, Dapodizo Electrical Division. Full stop. However, pursuant to which he had joined and was discharging his duties. Full stop. However, without any prior notice, the impugned order has been passed on 27/3/2025, by which his appointment has been cancelled. Full stop. Para. Sri L. Parme, standing counsel of the department, has, however, submitted that as per instructions received. Come on. It was detected by the department that the concerned executive engineer within bracket E was making appointments randomly without any approval. He has also placed on record certain office orders in this regard. Where that notice be issued, returnable by 4 weeks. Three permit, the learned standing council accepts notice on behalf of all the respondents. That extra copy be served upon him by tomorrow. Okay. Yes,
My lord, the matter is pertaining to the NIT. Wherein, my lord, I was also participated, and my case is that my technical bid was rejected, and thereby I was not allowed to go for the
Financial bid.
Financial bid. So being aggrieved of this, my lord, this was filed, and accordingly the interim order was passed by this honorable court on 14 December 2023. So, my lord, I am on a good faith. Out of the on the strength of this interim order, still I am on a good faith that the work should not be started and nobody should be awarded. Therefore, in the last years, that is in the years of 2024, I have been hankering after the respondent number, private respondent, that is respondent number 7 and 8, who are the responsive as per the evaluation matter. Now, my lord, it has been surprised to me on the last occasion, the department, from the department side, it has verbally submitted that the work in the NIT is carrying on, my lord. Therefore, my lord,
Work has been carried out through whom?
Exactly, my lord. If work is carried on, my lord, so, my lord, I have gone through the affidavit in opposition filed by the department. Nothing has been whispered about, my lord, who can, if at least, my lord, department able to say that the work order has been issued to the farm and private number, either 8 or 7, then I have the subsequent ground to file to challenge to that extent, whether the work order, if work order has been, my lord, awarded. So, my lord, after going through the affidavit in opposition, I found, my lord, nothing has been whispered. Therefore, I am still in belief that they, as per the strength of this interim order.
Is that all right? Is the work given to somebody in spite of the interim order?
My lord, I am not aware there is an interim order.
Huh?
I am not aware that whether there is interim order or not.
Which order? Interim order?
My lord, 14/12/23 and 19/12/23. 14/12/23.
Till then, finalization of the bid process shall be kept in abeyance. This is 14/3 and 19/3. What is it?
Shall be the
tender process shall be
subject to the outcome of the writ.
Shall be subject to the outcome of the
Yes,
petition.
yes.
There is no interim order.
No interim.
You can pray for an expeditious hearing. We can hear this matter. Because after some time, this matter will become infructuous if the work is completed.
My lord, my work
What is the magnitude of the work? What is the value of the work?
is around 9 crore, I think.
9 crore. What is the nature of the work?
Construction of road.
Construction of the road
Stretch?
around
How long?
18 month. 18 month.
No, not tenure. How long is the road length?
On length, it's not mentioned in the NIT.
No, it will be mentioned.
Yeah, it
Some
should be
meters or
mentioned.
kilometers. 9 crore will be maybe, I think 2-3 kilometers or I do not know, maybe more. What is the length?
But Malad so far that Malad work order value is Malad is 8 crore.
Mr. Modi, if you want, we can have your matter fixed for hearing,
Malad.
admission hearing.
And it is
The private respondent has appeared.
no, Malad, no private respondent has appeared. Therefore, Malad, I
Did you
need
take steps?
I need Malad this step has completed by the order of the last occasion, Malad, through the dusty service and through the postal service, Malad. Many effort has done and accordingly step was taken successfully. Now, my lord, one thing I want to confirm that whom awarded work has been awarded. At least to that extent, my lord, my argument.
7 and 8, you have made parties. 7 and 8 are the private parties.
My lord.
Then, if they choose not to appear, we'll hear both of you and we'll depart.
My lord.
7 is the
Till,
successful bidders.
till, my lord, in such situation, I need to ascertain from the department whom, whether 7 or 8, whom they have been, my lord, awarded to the work.
We will not be too much bothered. They have been served. They have not appeared.
My lord.
We'll go ahead.
7
First-
is.
First we see Modi.
My lord, my verbal instruction just now is that except 500 meter of CC drain or road furniture, physical work is already completed 90%. Then financial,
99%.
yes, financial also 95% already expenditure. So now at this stage, nothing remains.
My lord, I'll take instruction up to the.
Okay,
to
okay.
that.
Heard Sri C. Modi Learned Counsel for the petitioner, as well as Sri G. Tarak, Learned Standing Counsel.
RWD.
Sri Modi Learned Standing Counsel, Learned Counsel for the petitioner. Also heard Sri R. Tarak, Learned Standing Counsel, RWD. Full stop. Sri Modi, the Learned Counsel has submitted that it was that on the last occasion, it was verbally informed that the work was in progress. Full stop. He submits that such work could not have been allotted as there is an interim order operating. Full stop. On the other hand, Sri Tarak, the Learned Counsel, Learned Standing Counsel has submitted that though before issuance of notice, there was some kind of interim protection, some kind of interim order, the same was modified when notice was issued by directing that all actions taken would be subject to the outcome of the writ petition. Full stop. He has additionally informed that the work was duly allotted to the respondent was 7 and about 95% of the work has been completed in the meantime. Full stop. This court has examined, has carefully perused the orders dated 14/12/2023 and 19/12/2023. Full stop. By the first order, while an observation was made that till the next date fixed, which was 19/12/2023, finalization of the bid process would be kept in abeyance, while the subsequent order dated 19/12/2023, on which date notice was issued, it was observed that the tender in question would be subject to the outcome of the writ petition. Full stop. Therefore, it cannot be accepted that there was a restraint in the execution of the work. Full stop. Be that as it may, on the submissions made by the Learned Standing Counsel regarding the progress of the work, Sri Modi, the Learned Counsel for the petitioner, prays for and is granted 2 weeks' time to obtain necessary instructions regarding the future course of action. List after 2 weeks.
Obviously.
Item?
May I, Lordship?
Yes.
Lordship, this is regarding the dealership of petrol pump, Lordship. We have taken steps to dust the service last occasion, Lordship, and the same was already filed, Lordship.
Affidavit filed?
Yes, Lordship.
Dusty upon?
Respondent number 1 and 2, Lordship.
Who are 1 and 2? Bharat Petroleum.
Bharat Petroleum, Lordship.
Bharat Petroleum does not have a standing counsel.
No, Lordship.
Mr. Tarak, Where is it? You appeared for IOC or something earlier? This is, Bharat is not connected with IOC.
No, I am.
Who appears for Bharat Petroleum? Anybody?
Tapa, I think.
Huh?
I have no
Tapak
idea.
appears.
I have no idea, Lordship.
Inform him, just casually, informally, not formally, that about this case. Will otherwise accept your affidavit, okay?
Yes.
Heard.
Legal Lordship.
Learned counsel for the petitioner who submits that pursuant to the no, there is already an order that it is complete. Then we'll issue rule and make it returnable. Okay. But there's an interim order, isn't it?
Yes, Lordship.
You give us a date. If they are not appearing, we'll appear here. Hear this matter. Okay. What do you write? That the aspect of service upon the respondent numbers 1 and 2 has already been examined by this court and orders have been passed that such service is complete. Even today, he has also drawn the attention of this court. And don't write this today. Even today, there is no representation on behalf of the respondents. Para, in view of the above, please for admission hearing in the 3rd week of June 2025. Para, interim order passed earlier to continue till the next date of listing.
Much obliged.
Next date will dispose of the matter. Remind the report. Mr. Saikia, what is this?
I'm challenging the appointment of the Gaura of respondent number 3, madam.
Why is it come for orders? Affidavit and reply yet to be filed. Filed or not?
I will not file, my lord.
Will not file.
My lord.
You are for the private respondent.
Yes, Lord.
And Mr. Tapin?
Yes, I am for estate respondents.
If you want, we can take it up, but order stage, we not know whether we better okay or not.
Or since party are ready,
Because, my lord, we have also filed the, my lord, the writ petition by annexing, my lord, guidelines, which is not applicable, my lord. And the state also relied upon a guideline, my lord, which is further, my lord, amended by the state government, my lord. But
Okay, we can try for a disposal.
my lord, before coming to the, my lord, effect of the case, my lord, kindly, my lord, peruse the, my lord, guidelines for, my lord, appointment of the Gaura, my lord.
No, first, tell us the facts.
Facts, my lord. My lord, the petitioner, my lord, has read up to class 10, my lord, and was appointed as a Gaura.
This is a 19 matter.
2019 matter. My lord.
Oh, yes, yes. Disposal is required.
Petitioner was appointed as a Gaura on
R.
20.
Saikia for petitioner, then S. Tapin. And here for respondent number? Item number, what is this item number?
I'm for respondent number 2.
What is your name? Mdozi?
V Jamal.
Vijamu. For
Respondent number 3, private respondent.
respondent number?
3.
3, R3.
My lord, because, my lord, we are relying on, my lord, different guidelines, my lord. In a similar case, my lord, by this order of this honorable court, my lord, in another case, my lord, the honorable court has directed the state government to, my lord, to produce the, my lord, the guidelines which is being followed at present, my lord.
Well, we need the guidelines which was in operation when the impugned decision was taken.
Lordship.
You may have a different guideline as on today, that cannot have a retrospective effect.
Yes, Lord.
So we need the guidelines which were in operation at the time when you had taken the, have you got the guideline? Okay.
We have also.
Yes. Yes. What is the case about?
The petitioner, my lord, was appointed as a
You
Gaon
have read up to class 10.
class 10, my lord. Was appointed as a Gaon on 22/4/2022.
22/4/22.
2002, my lord.
2002.
2, my lord. Of Sido village, my lord. Gaon of Sido village.
What village?
Sido, SIDO, Sido village.
Which district?
East Siang district, my lord.
Yes.
And my lord, the respondent number 3 was appointed as a Gaon on 28/3/2012, my lord.
2012.
12, my lord.
Of
same Sido village, my lord.
after you.
Yes, my lord.
You had your tenure was over.
No, no.
There is no tenure as such.
No, no tenure, my lord.
Then
my lord, my lord,
now how was it possible if you are the Gaubura existing without cancellation?
no, no. I am a Gaon, my lord, appointed a year in the 2002, my lord.
Yes.
And respondent number 3 is further expired in the year 2012, my lord. In his place, my lord, the respondent number 3 was appointed as a Gaon.
Of what? Which village?
Sido village, my lord.
No, but you are already the Gaubura. How many Gauburas can be
There
there?
are 3 Gaon, my lord.
3 Gauburas.
Yes, my
Okay,
lord.
tell us. Okay. So 3 Gauburas are possible. Okay.
Yes, my lord. To be headed by one head Gaon, my lord. And his education qualification is read up to class 8, my lord. I have annexed the education qualification also, my lord. My lord, I am sorry, my lord. He was respondent number 3 was appointed on 26/4/2012, my lord.
Not 28/3.
Not 28/3, my lord.
26/4/2012,
my lord.
Okay.
In the vacant post of my lord, head Gaon, on the device of Obang Sirang, my lord, the father of respondent number 3, my lord, I represented myself, my lord, for appointment and promotion to the post of head Gaon, my lord.
There was another Gaumbura. Third Gaumbura was also there.
There, my lord. But in a village, my lord, there may be 1, 2 or 3 Gaon, my lord, and it is to be headed by one head Gaon, my lord. On the expiry of my lord, respondent number 3's father, Obang Sirang, my lord, I represented my lord myself for promotion to the post of head Gaon on 17/8/2012. Saying that, my lord, I am senior most, my lord, Gaon, my lord, of that village, my lord. Again on 25/6/2014, represented, my lord. And again on 3/9/2015, my lord. 25/6/2014, and again on 3/9/2015.
2014 and
3/9/2015.
Further representation.
My lord.
Okay.
My lord, accordingly, my lord, CO Kora, my lord, Circle Officer Kora Circle, on 30/8/2016, my lord. 30/8/2016.
Yes.
Has forwarded my application, my lord, along with the seniority list of the Gaon of Sido village, my lord, wherein, my lord, I am the senior most head Gaon, my lord. This was forwarded to, my lord, ADC Nari, who is the appointing authority, my lord, in terms of section 5 of the regulation, my lord.
Which ADC?
ADC Nari, my lord. NARY, Nari, my lord.
RI.
RI, my lord. RI. On the same date, my lord, on the same date, that is 30/8/2016, my lord, one, my lord, Gaon, Tariq Kaki, my lord, who is the brother-in-law of the respondent number 3, has forwarded, my lord,
an application matter for appointment of my lord respondent number 3 as a head Gaupura my lord. Now it is important my lord. This my lord, kindly see at page 49 my lord.
49.
My lord.
Yes.
By the my lord Tarak T Kaki my Tarak Kaki my lord GB Sido Blaze my lord. To the additional deputy commissioner East Siang district through CO Korang my lord. Submission of minus of meeting for HGB Sido Blaze. With due respect, I on behalf of the Sido Blaze like to submit herewith minus of the meeting for appointment of the HGB of Sido Blaze held on 18/8/2016. My lord, it's a crucial date, my lord. In the meeting, Sri Tapang Siram have been selected as HGB of the said Sido Blaze by majority of the blazers, my lord. That's why, my lord, now, my lord, the rules has to be perused, my lord. How the, my lord, appointments are being made, my lord. So rule provides, my lord. Here, my lord, may I kindly peruse the rules, my lord. The rules applicable, my lord, as on date, my lord.
Yes.
Procedure, my lord.
Guidelines.
Guidelines, my lord. Page 2, my lord. Next page, my lord. Mode of selection, my lord.
Page 2. Yes.
Mode of selection, my lord.
Clause 2.
Clause 2, my lord. Subclause 1, my lord. The basic character of this age-old customary institution is character democratic. Therefore, the method of selection be through anonymous or through majority opinion of the adult residents, my lord. Madam, kindly note this, my lord. Adult residents of Blaze at a full and open meeting of all Blaze adults to be conducted in presence of an administrative officer, my lord. In presence of an administrative officer of the area. The quorum for such a meeting will be 1/3 of the total number of persons above 18 years, my lord. In the Blaze, my lord. Meaning there, my lord, all the, my lord, Blazers, my lord, who are above 18 years of age are, my lord, eligible to, my lord, select the Gaupura, my lord. Next, my lord. The meeting shall be, my lord.
Yes.
Be close B subclause 2, my lord. Subclause B of 2, my lord. The meeting shall be convened and attended by administrative officer of the area, conducted in free, open, and unbiased manner. The administrative officer will explain to the Blazers present in the meeting of the qualification of the person must possess for a greeting elected as Gaupura, and also bring to their notice that the person selected as
It should be getting elected.
Getting
For getting elected,
my
not
lord. Getting my lord. For getting elected as Gaupura should be persons with influence and acceptability in the Blaze, should possess knowledge of customary law, as well as he should have an interest in the development of the Blaze. He will also explain the circumstances, conditions which will disqualify a person from being elected as a Gaupura or will lead to his dismissal even after the selection and appointment. My lord, here is this guidelines talks about only the Gaupuras, my lord, not head Gaupura, my lord. C, my lord. The administrative officer concerned shall maintain records of the proceedings of the meeting, along with the records of all those present in the meeting. He will then forward the name of the person selected as Gaupura along with his biodata and character and antecedent report, the proceedings of the meeting, and his recommendation of the to the deputy commissioner. D, my lord. The selection made by the majority opinion will not be binding on the deputy commissioner, my lord. Concern for appointment of the Gaupura.
You have See, the expression which has been used in B is only Gaumbura and not head Gaumbura.
Not head Gaumbura.
But if you come to the first clause, number 1, appointment.
Yes, my lord.
The appointment process is for both HGB
Both,
and GB.
yes, my lord.
And there is no separate mode of selection
For head Gaumbura.
for head Gaumbura.
Assuming that, my lord, this rule will also be applicable for the head Gaumbura, my lord. Now the procedure adopted, my lord, and before that, my lord, kindly again see, my lord, the internal page, my lord. For page 3, my lord. Clause 5, my lord.
Person.
Numbers of head GB in a village, my lord. Clause 5, my lord.
Yes.
1 GB will be appointed for a village having population of 100 or less. For village having population more than 100, 1 GB will be appointed for every 100 persons, subject to a maximum limit of 10 GBs for a village. For this purpose, numbers above 50 will be rounded up as to a next 100. A village having 5 or more GBs will be entitled to have a 1 AGB, my lord, by the Deputy Commissioner, my lord. Now, my lord, the procedure adopted by the
village having 5 or more
my
GBs
lord. Yes, my lord.
will, no village will have more than 2. A village having 5 or more GBs will be entitled to. That means the minimum number of Gaumburas
My lord.
which you have to have a head Gaumbura is 5.
5, my lord.
In your village there are only 3.
3 Gaumbura, my
So
lord.
there is no provision of head Gaumbura.
But earlier there was a head Gaumbura and the post fell vacant, my lord.
Now, if some decision was taken earlier,
My lord.
which was erroneous, not in accordance with law, he retires, then under what provision of law will you be appointed as the head Gaumbura?
This is one of the question, my lord. And my lord,
Rule says that minimum 5 head Gaumbura
Gaumbura.
is required to have a head Gaumbura.
in terms of the, my lord, this guidelines, my lord.
Mr. Jammu's client has been elected as head Gaumbura.
Yes, my lord. This is under state, my lord. It is put under state, my lord.
But you also want to become a head
Head
Gaumbura.
Gaumbura, my lord.
Mr.
My lord,
Tapin, can you appoint a head Gaumbura for this village?
Lordship, as per guidelines, Lordship, and the field Lordship, it's happening Lordship. Because in a blade Lordship, 2 Gaumburas are there Lordship. Someone has to lead the Lordship, the forum Lordship. So therefore one.
But if the rule says that minimum 5, and admittedly you have only 3.
3 Lordship.
So the question of appointing head Gaumbura may not arise at all.
Lordship.
But if you are saying that our practical purpose, even for villages having 3 Gaumburas, you can still appoint a head Gaumbura, then what procedure are you adopting?
Yes. That part is now Lordship, in present case Lordship, what I would like to propose is the Lordship. Apparently Lordship, the mode that procedure has not been followed Lordship. So it can be remanded back to the authority to conduct a meeting and to appoint as per the rules Lordship. If they are Lordship, this village is eligible to have Gaumbura.
Head Gaumbura.
Head Gaumbura Lordship. As per the guidelines, then accordingly, as per the procedure, by following procedure, someone may be appointed. Case of the petitioner or as well as the private respondent can be considered, and they
Mr. Jammu, what do you say?
That is also there, Your Honor, but Lordship, I have been appointed after a duty consultation by the village, one of the Gaumbura has proposed me since Lordship in
you have also gone through the rules. Rule said that in the meeting, there should be a person from the administration.
Yes.
Was a person from the administration present?
There was no, that is not there.
There is apparent infraction of the rules. We are not saying that straight away Mr. Saikia's client should be appointed. He says that he is class 10 pass, you are class 8 pass. There are other criteria which are to be taken into consideration. Though Mr. Saikia has said that those are for Gaumbura, but since the appointment is almost the similar, so even those aspects will be taken into consideration. But more important is the objective criteria, whether the meeting was in accordance with law. Number 1, the presence of a person from the administration. Number two, quorum, minimum 1/3 of persons more than 18 years. Those are not reflected here.
Here, in fact, my lord, the minus of meeting, my lord, kindly peruse for a moment.
But Mr. Sakya, in the order, we'll also have to make an observation that if at all a head bura, head gaon bura is permissible under the rules, or for practical purpose they want to appoint, then they will get.
In accordance with the guidelines.
accordance.
Yes, madam. Well, for a moment, kindly, my lord, peruse the my lord, minus of the meeting, my lord. It was not headed by the my lord, the administrative officer in present.
That's what, Lordship, I'm just,
That we are saying.
we're
Which
admitting.
page?
purpose.
Page 50, my lord.
But Lordship, from here the meeting, we can say the majority of the villager and then the one of the Gambura has selected me to lead the village.
Now, under what provision of law?
This,
How
Yes.
can a gaon bura select you?
And all the adult members were not considered, my lord. Only in the Sido village, my lord, there are altogether 20 houses, my lord. And each house was represented by a single person, my lord, which is not permissible, my lord. The rule guidelines says, my lord, the adult member of the village, my lord. My lord, kindly,
50 is the impugned order.
it is also, my lord, impugned order is the, my lord, appointment order, my lord.
Page.
Page, my lord. Page, my lord, 58, my lord.
Dated.
Dated, my lord, 4/3/2019, my lord. 4/3/2019, my
But
lord.
this was, minutes was of 16.
Yes, my lord.
Till 19, what was going on?
My lord, therefore, my lord, this, my lord, minus of the meeting was returned back by the ADC, my lord. As the my lord, minus of meeting was not, my lord, conducted in presence of the my lord, administrative officer and not by the all village elders, my lord.
Then why was it again considered?
This because of the my lord, interference by the my lord, government, my lord, through Chief Minister, my lord.
there is.
Yes.
that-
My lord, kindly see, my lord.
There is because at that point of time, Lordship, there was a dispute in this village, whether this village was supposed to be in Lower Siang or East Siang district. That was only.
My lord, kindly again see, my lord, page 52, my lord. This, my lord, recommendation by the one of the Gaon was returned back by the ADC to the circular at page 52, my lord. On 9/6/2016, my lord. May I read, my lord? By the ADC to the circle officer Korang.
Okay, we'll dispose of. Okay. The issue which has been raised by means of this petition filed under Article 226 of the Constitution of India pertains to the appointment of head gaon bura. Full stop. The petitioner has put to, no, don't write, head gaon bura, full stop. As per the facts projected, the petitioner who has read up to class 10 is fit to be eligible as gaon bura of a village. Why didn't you pass matriculation? Did you appear or
I
not?
don't have that instruction, my lord.
Oh, don't laugh, Mr. Jammu. You have not even passed class 8.
Usually, Lordship, the Gambura, they are hardly this the class 2, 3 or maybe.
2, 3.
Because in that
To become a gaon bura, you are not supposed to study.
no, Lordship, now they have made a criteria. One should be a class 5 pass, something like that, Lordship. But only just one who has no knowledge of the local customary.
That is
law.
more important.
It is more important, Lordship.
Your client has.
Yes, Lordship. That's why he was selected by
It
the
seems
village.
you are also having the knowledge. Okay, yes. Class N is eligible to be appointed as a gaon bura of a village. Full stop. Accordingly, on 22/4/2002, the petitioner was appointed as the gaon bura of Sido village in the East Siang district. Full stop. In the said village, the father of the respondent number 3 was also a gaon bura, who was also who was the head gaon bura, who had passed away. And on his expiry, the respondent number 3, by order dated 26/4/2012, was appointed as the gaon bura. Full stop. Since, according to the petitioner, he was the senior most amongst the gaon buras, he had submitted representations to appoint him as the head gaon bura, which post had fallen vacant on the death of the earlier incumbent. Full stop. The representations submitted by the petitioner were finally taken into consideration, and the circle officer Kora, via communication dated 30/8/2016, had forwarded the said representation by enclosing a seniority list. Full stop. It is the contention of the petitioner that in the said list, he was stated to be the senior most. Full stop. The matter was forwarded to the ADC Nari inasmuch as per clause 5 of this same regulation, as per clause 5 of the guidelines for appointment of gaon buras in Arunachal Pradesh, the ADC is the appointing authority. Full stop. However, on the same date, that is i.e. 30/8/2016, a representation was submitted by one Tariq, what?
Tariq Kaki,
Tariq Kaki,
gaon bura,
who is the gaon bura of the same village, by which a minutes of meeting dated 18/8/2016 was forwarded. Full stop. As per the said minutes, the respondent number 3 was selected as the head gaon bura. Full stop. Para. Consequently, not para, consequently, an order dated 4/3/2019 was passed appointing the said respondent number 3 as the head gaon bura. Para. I have heard 3. No, don't write that. It is this section which is the subject matter of challenge in the present writ petition. Then para. I have heard 3 Arsaikya, learned counsel for the petitioner, semicolon, 3 Estapin, learned senior gaon advocate, and 3 J.V. Jamu, learned counsel for the respondent number 3. Para. 3 Saikya, the learned counsel for the petitioner, has submitted that the selection and appointment of the respondent number 5 as head gaon bura is not at all in accordance with the law and norms holding the field. First of all, he has submitted that apart from his client being senior from the point of view of tenure as gaon bura and also possessing higher qualifications, instead of considering the case of his client, the respondent number 3 was appointed as head gaon bura. Full stop. He has submitted that such appointment has been done simply on the basis of a minutes of meeting held on 18/8/2016, which was forwarded by another Gambura, who is none else but the brother-in-law of the respondent number 3. Para? By drawing the attention of the guidelines, the learned counsel for the petitioner has submitted that under clause 2, the mode of selection has been laid down, as per which the appointment of Gambura/head Gambura is to be made in a meeting of the village in the presence of an administrative officer, and the quorum is one-third of the persons above 18 years. Full stop. He has submitted that a bare perusal of the minutes of meeting dated 18/8/2016 would show that it was not held in the presence of the administrative officer. Full stop. He has also submitted that only one member of the household was present, and there is no proper representation of the adult members, which is provided by the guidelines. Full stop. He has also informed that initially the minutes of meeting dated 18/8/2016 was not acted upon by the authorities, as there was apparent violation of the guidelines. Full stop. However, due to certain extraneous consideration and political interference, the appointment was finally made on 4/3/2019, by which the respondent number 3 was appointed as the head Gambura. Full stop. The learned counsel submits that there is total violation of the norms holding the field in the said process, whereby the petitioner was deprived of a fair opportunity for his consideration for appointment as head Gambura. Para 3. S. Tapin, learned senior government advocate, in his usual fairness, has submitted that from a reading of the minutes of meeting dated 18/8/2016, it does not appear that the guidelines holding the field were adhered to. Full stop. He has accordingly submitted that the matter may be remanded back for making a fresh selection in accordance with law. Full stop. He has, however, hastened to submit that so far as the eligibility and suitability is concerned of the petitioner vis-a-vis the respondent number 3, the same is to be considered in accordance with law, and he is not making any comments, any submissions on the said issue. Para. Sri Jamu, the learned counsel for the respondent number 3, has, however, defended the impugned action. Full stop. He has submitted that the father of the respondent number 3 was the head Gambura who had passed away on who had passed away, and on his passing away, the respondent number 3 was initially appointed as a Gambura on 26/4/2012. He has also submitted that the educational qualification is not a relevant material, and what is relevant is to have knowledge about the customary laws which his client possesses. Full stop. The rival contentions have been duly considered and the materials placed before this court have been carefully examined. The challenge, as would reflect from the preceding discussion, is on the aspect of the appointment of the respondent number 3 as head Gambura of Sido village wide order dated 4/3/2019. Full stop. The basis of passing the said order was a minute submitting dated 18/8/2016, which was forwarded by one of the existing Gamburas. Full stop. It is alleged that the said Gambura who had forwarded the minutes is a brother-in-law of the respondent number 3. Full stop. The guidelines holding the field, which has been noted above, lays down the mode of selection. Full stop. As per the same, the appointment this has been noted down. Full stop. The aspect of appointment pertains to both head Gamburas and Gamburas, and same is to be done as per the provisions of section 5(1) of the Assam Frontier within bracket Administration of Justice bracket close Regulation Act 1945. Full stop. As regards the mode of selection, though the expression of Gambura is only used since the same is preceded by the clause regarding appointment, wherein both HGB and GB are mentioned, it has to be construed that the same mode of selection is to be adopted even for head Gambura. Full stop. As per the said guidelines, such appointment is to be done in a meeting of the village, which is to be attended by all the adult members. Full stop. What is more important is that the meeting should be done in the presence of an administrative officer, and the quorum has also been fixed to be 1/3 of the persons above 18 years of age. Full stop. A bare perusal of the minutes dated 18/8/2016 would show that none of the aforesaid conditions were adhered to while holding the meeting. Full stop. The aspect of delay of about 3 years in acting on the said minutes of meeting would itself raise serious doubts as to why the respondent authorities had ultimately taken a decision to make such appointment, in spite of the fact that the minutes of meeting dated 18/8/2016 were in apparent aberration of the guidelines. Full stop. Para. Though the petitioner has also raised the issue of bias in as much as the forwarding letter dated 30/8/2016 was issued by a gaon bura, who is the brother-in-law of the respondent number 3, this court would not embark upon the said issue, inasmuch as it has already been held that the meeting was not held in accordance with the guidelines holding the field. Para. It is a settled principle of law that when a particular method is prescribed to do a thing, that thing must be done in the prescribed method only and in no other way. Full stop. In this connection, one may gainfully refer and rely upon the observations made by the Honorable Privy Council in the celebrated case of King Emperor versus Nazir Ahmed, reported in 1936 PC. maybe 253, wherein the following observations were made. Para. In view of the aforesaid discussion and taking into account the rival submissions, the present writ petition is allowed. Rival submission. This court directs. This court is of the opinion that the impugned action is not sustainable in law. Full stop. Accordingly, both the minutes of meeting dated 18/8/2016, which had culminated in the order of appointment of the respondent 3 dated 4/3/2019, are set aside. Full stop. The matter is accordingly remanded back to the authorities to undertake a process for appointment of the head gaon bura of the village, which, however, has to be done strictly in accordance with law and by the guidelines holding the field. Full stop. It is, however, clarified that no opinion of any nature has been expressed by this court on the eligibility of the rival parties, which is to be assessed in the said meeting to be held in accordance with law. Para. Writ petition is accordingly allowed to the manner indicated above. Para. No order is to post.
One more question. Here, Lordship, the petitioner has filed a petition by saying that the authority has relied most of the 2001 guidelines. Lordship. Now, we too have replied that we have done as per the 2001. Now, that has been amended and 2005 is enforced now. Lordship. That maybe is specified that when Lordship has already observed as per the law, then this particular may be referred.
Yes.
Okay. One particular. before the last paragraph. Input is accordingly allowed to the just before that. At this stage, the learned state counsel, Sri Tapin, has informed this court that presently the guidelines of 2005 are in operations, full stop. It is needless to say that it is the existing guidelines which are to be taken into consideration for carrying out the process of appointment of head gaon bura / gaon bura. That these are partly allowed. No? Make it in the form of a judgment. Judgment. Right? বদলি আছে এইবিলাক সব ঠিক আছে ৰঙাটো ৰঙাটো নাই খাবৰ এইটো এটা খবৰ পঠাই
May I lordship? My lord, I may be allowed, I may be given 2 weeks time.
For?
To serve notice upon the respondent number 2, that is the incumbent CCF, Chief Conservator of Forest.
I'm for 1 and 3, your lordship.
Office note dated 21/5/2025 reflects that fresh steps for service of notice upon the respondent number 2 has not yet been taken. Para, Sri so learned counsel for the petitioner prays for some time to take fresh steps. Let fresh steps be taken upon the respondent number 2 by registered post with AD by Monday next. List after 4 weeks along with service report. Sri so your name has appeared for the respondent numbers
1 and 3.
1 and 3.
Yes, lordship.
Obliged.
Obliged.
My lordship.
Yes.
Lordship, service report in respect of respondent note by which the levy. I have taken the step on press step, lordship, on 22/7/2024.
22/7?
2024.
2024?
Yes, lordship.
Who is respondent number 5? Private respondent?
Private respondent.
From 7 to 20, now it's very late. You take fresh steps.
My lordship,
And will direct this matter to be listed after 6 weeks. If a similar situation arises, we'll invoke the provisions of deemed service. So now after 1 year, it will not be proper. Okay. In view of the peruse the office notes dated 22/7/2024 and 21/5/2025. Full stop. In view of the above, Sri so learned counsel for the petitioner is directed to take fresh steps for service of notice upon the respondent number 5 by registered post with AD. Steps by Monday. They give the date. List after list after 6 weeks along with service report. Full stop. If a similar situation regarding service upon the respondent number 5 arises as reflected in the office note dated 21/5/2025, this court would pass appropriate orders on deemed service. Ms. R. Basar, learned state counsel, is present for the official respondents.
My lordship, there is interim order, lordship.
Interim order passed earlier to continue till the next date of listing. You have got your name, no? What is name?
Number 19.
19 years. Mr. Tarak, what is this? Oh, Tagum is not, he is not there today.
Yes.
Yes. Like to take time for Tagum? Three so and so Learned Council has prayed for an adjournment on behalf of Sri T. Tagum.
Yes,
Learned Council for the petitioner. Para? Sri G. Tarak, Learned Standing Council RWD is present. Para? List after a week. You write his name, huh?
Number 22.
Your Lordship, I'm sorry to say, I couldn't connect because of the network connectivity issue there, Your Lordship.
Oh, yes, we have.
Yes, Your Lordship.
But
I've
I
been-
don't think there is anything to disbelieve this. We close this.
In case tomorrow they say,
How can this be?
yes,
Who had given you this? Your client?
yes,
Yeah. Why should he produce the documents which will be to his prejudice?
Yes,
in
Your
that case,
Lordship.
now this repetition may be
Yes.
as infructuous.
Yes. Third, Sri B. Picha, Learned Council for the petitioner. Also heard Sri Y. Ram, Learned State Council. Full stop. Para. Considering the subject matter and also the development which has taken place in the meantime, the petition is taken up for disposal at the admission stage itself. Full stop. Order is listed but is not yet admitted. Has rule been issued?
No, my lord, only notice.
Rule has not been issued.
No, Your Lordship.
Admission stage itself. Full stop. Para. As per the facts projected, the private respondent had lodged a complaint before the ADC. Monigong.
Maniga.
Why is Monigong?
Mechuka, my lord, it is in Siomi district.
Sriomi is a new name.
Yes, sir,
Yes,
Siomi new
it
district.
has
It
been
is carved out
bifurcated.
from West Siang.
Yes.
Monigong, Sri Yomi district against against the Sazi clan with regard to the encroachment of certain areas. And on receipt of the said complaint, the ADC had passed the impugned order dated 30/9/2024 directing conduction of a Kebang on 25/9/2024, by which the Kebang committee was also constituted. Full stop. It is the case of the petitioner that the ADC did not have the jurisdiction.
Does not have the authority to take cognizance of a complaint and constitute a kabang.
Did not have the jurisdiction or authority to even to take cognizance of any complaint and to constitute
Yes, sir.
the Kebang. Full stop. Accordingly, the writ petition was instituted. Full stop. Para. While issuing notice by this court in the instant writ petition on 3/10/2024, it was observed that any decision taken by the Kebang would be subject to the outcome of this writ petition. Full stop. Para. Sri Picha? No, para. I have heard Sri B. Picha, Learned Counsel for the petitioner, as well as नहीं लिखा ना नाम नहीं लिखा फर्स्ट में नहीं लिखा ना आराम शुरुआत में we have not read. Did we write? We have written, be Picha and so and so. Don't say, don't write hard then. Last my hard listen. Sri Picha, the learned counsel for the petitioner, has appraised this court that after the aforesaid order, no proceeding was, the matter was not proceeded with by the Kebang. Full stop. He has also informed this court that subsequently an order has been passed on 19/11/2024, whereby the decision dated 13/9/2024 of Constitution of the Kebang has been cancelled. Full stop. He has also placed on record copy of the order dated 19/11/2024. Full stop. Para. Also heard Sri, Sri so-and-so London State Council has submitted that he does not have specific inputs on the specific instructions on the aforesaid development. First of, however, he submits that if such an order has been passed, the same may be taken into consideration and the writ petition and appropriate orders may be passed in the writ petition. Full stop. Para. After hearing the parties and on perusal of the order dated 19/11/2024 issued by the ADC of the concerned district, whereby the Kebang committee formed on 13/9/2024 has been cancelled, this court is of the view that the grievance of the petitioner has been substantially redressed. Full stop. Accordingly, this writ petition is not required to be proceeded any further and the same is closed. Para. Copy of the order dated 19/9/2024 placed before this court by Sri Picha is made part of the record.
Obliged.
My lord, what I pray, my lord, the entire writ petition may be disposed of, my lord. The writ petition may be disposed of, my lord. The pleadings are complete, yes, my lord.
Pleadings are complete, my lord. 25 is my IA against the interim order, my lord.
Against the interim order?
Interim order. There I am the applicant and I am respondent number 7, private respondent number 7 in the writ petition, that is 26. Now,
So if you are agreeing to Mr. Picha's proposal to take up the writ petition,
yes,
we may not.
yes, my lord, very well. Yes.
Consider there will be no requirement to consider the IA.
IA, my lord, yes. According to me, my lord, this is covered and this has become infructuous because after the interim order, there was a division bench order challenging the same award that has been passed, upholding the award, my lord. So that interim order records that fact. The division bench is pending and whatever I am.
What has happened in the division bench now?
My lord, the division bench has upheld the award, my lord. The notification and the award has been challenged here also by them.
Then will there be
No, my
anything
lord,
to be?
the course of action there is different, my lord. I will submit.
No, are you disputing the aspect that the challenge before the DB?
Yes, it's totally different.
Different?
Yes, my lord.
Well, look, different on the grounds and the cause of action, but the award and the notification is the same, and that has been upheld by 2 division bench and also the SLP. So I have the list, entire list I prepared. I will take 5 minutes. If
My
the
lord,
permits me.
I will say, my lord, this private respondent is a fraudster, my lord. What happened, my lord? He is not from our village, my lord. He has been filing litigation after litigation before this honorable court, saying that he is from my village, my lord. Now I filed this writ petition saying that he is not from my village. Now he changes his village. So land acquisition has been initiated, has been processed over my land, my lord, over my community land of my village, of Malini village.
But if the issue has been decided.
No, not decided, my lord. That is why I will clarify everything, my lord.
Okay.
My lord. I will start with Lara Act of 2013, my lord. Substantial ground, my lord. Section 11, my lord. My case is non-compliance of section 11 and section 15, my lord. Of Lara.
Just to, all these grounds were before the division bench, my lord. Except one, which my learned friend declared.
Okay.
My lord. May I, my lord? Section 11.
You, Mr. Biswas, for response number?
7, my lord.
And the state is for, state you are there, Mr. Ram? Okay. 1, 2, 3. And anyone else? 4, 5?
4, 5, 6 is my
The central government.
central government. They already have the land. They have deposited the amount, and out of 5 beneficiaries, my lord, 4 payment has been released after the division bench order. Only because of the interim order, only this respondent number 7 payment has not been released.
Okay, what is your case?
Yes, my lord. Section 11, my lord. Non-compliance of section 11 and section 15, my lord. Section 11 of Lara. Publication of preliminary notification and power of officers thereon.
You are referring to 2013 Act?
Yes.
Right to fair
Yes,
competition?
yes, ma'am. Section 11, ma'am.
Yes, please.
Yes, my lord. Section 11 B, C, E, and subclause 2 has section 11 subsection 1 B, C, and E has not been complied with. No newspaper publication in 2 local newspaper, my lord, and 1 regional.
And which one?
And C, and no notification in locality.
No, there's 11, 1, B, C, and E.
B, C, and E, my lord.
And
Yes.
thereafter, anything? 2.
Gram Sabha, there was no Gram Sabha held, my lord.
You say that those violated. These provisions were violated.
Yes, my lord.
There was a land acquisition proceeding.
Yes, my lord. Was not complied with.
Which is the subject matter of challenge.
Yes, my lord.
And you allege that this land acquisition, the same land acquisition proceeding is violative of this. It was done without complying with the requirements
Yes,
of.
yes,
Okay.
my lord. So no, and my lord, this.
Who are you? You are the affected party.
Yes, I am from that village.
Okay.
This is regarding to Malini village, madam. And that land is situated at Malini village.
Malini.
Yes.
Where is it?
Dibang Valley, my lord. Dibang Valley district, madam.
Okay.
Now section 15, my lord, hearing of objections, my lord. This was, my lord, since there was no paper
And
publication.
who is Mr. Biswas?
Biswas is from Ichanli village, my lord. He is from different village, my lord.
So why have you made him a party?
Because award has been passed in his favor, my lord. Land acquisition award has been passed in his favor, my lord.
I'll respond to that. No one's fine.
There was a land acquisition proceeding.
Yes, without following the procedures.
Culminating in an award.
Yes, my lord.
Award in his favor.
Yes, my lord.
He is the beneficiary of the
Yes,
award.
yes, my lord.
But you said that you are the affected party.
Yes, my lord. So fraud has been caused to us, my lord. Fraud, my lord. Because we were not informed, my lord. No paper publication was, because we were not aware of, my lord. No paper publication was done, my lord. No, my lord, the compliance of section 11 has been totally compromised, my lord. There was no transparency, my lord. And in that case, my lord, section 15 also comes into play, my lord. No opportunity for claim in objection. My lord, section 15 says person interested, my lord. Person interested has been defined in section 310, my lord. 310, my lord. X, my lord. And affected area has been described in section 3B, my lord. Affected area, my lord.
A paragraph, section 18.
Section, my lord, section 3X, my lord, is the definition of person interested, my lord.
Yes.
One, my lord.
Yes.
All persons claiming an interest in compensation to be made on account of the acquisition of land under this act. The scheduled area so and so, my lord. A person interested in an easement affected the land. Person having tenancy rights over the relevant state laws, so and so, my lord. any person whose primary source of livelihood is likely to be adversely affected, my lord. Now, affected area, my lord, has been defined in, my lord, section 3B, my lord. Affected area means such area as may be notified by the appropriate government for the purpose of land acquisition, my lord. 3B. The definition close, my lord. Affected area, my lord, this affected area has been enumerated in section, also in section 11E, my lord. So publication has to be made in affected areas, 3E, in the affected areas in such manner as may be prescribed.
11E.
In the affected areas, 11E.
11E. 1E.
Yes, 11(1)E, sorry.
Okay.
And section 15 starts with any person interested, my lord. The person interested has been,
15.
yes, 15, my lord. Hearing of any person interested, my lord.
Yes.
Yes, my lord. May I? Read petitions, my lord, are in 49 in numbers, my lord.
49 repetitions.
49 in numbers. My lord, what happened, my lord? This private respondent claiming to be the resident of permanent resident of Malini village has filed a writ petition before this honorable court, my lord. My lord, that may be found. I have collected my annexures from the writ appeal, my lord. So, my lord, may kindly peruse page 189, my lord. Page 189
Of the repetition.
of the affidavit in opposition filed by respondent number 7, my lord.
One eight nine.
189.
He had initially filed what writ petition? WPC?
78 of 2017.
This one.
Yes, 189. Yes. My lord, may please come to page 190.
Gasimena.
Nasimena, yes, he is the private respondent.
Okay.
Page 190, my lord. Now. His address, my lord. He is a permanent. He claims he is a permanent resident of Malini village, my lord.
Yes.
Now, by basing on that, my lord, he has filed a writ petition, my lord. Now, my lord, may please come to page 193 of the judgment, my lord. 193, my lord. Fourth paragraph, my lord. It is the case of the petitioner that the writ petitioner is a permanent resident of Malini village under Italian Circle, under the Dibang Valley district, and their community land has been taken by the so and so. Now he claims this land is a community land, my lord. By way of this writ petition. Now, my lord, may I travel, my lord? My lord, may I please come to writ petition, my lord. I am showing that because now he is claiming that the land is a private land. His private land, my lord. Initially, he claimed the land is a community land. Now he is claiming the land is a private land, my lord. His private land.
Okay.
Yes, ma'am. Annex to page 52, my lord. Writ petition now. This before submitting, my lord, I would like to submit that entire writ petition, my lord. The annexures has been, my lord, taken from the writ appeal, my lord. We do not have the records. So why, my lord? And we have also stated in our writ petition. Now, page 52, my lord, this was a draft notification, my lord.
52 of the writ petition?
Yes, my lord.
No, 52 is your affidavit. Of what? Of the present writ petition?
Present writ petition, my lord.
52.
Yes, my lord. 5-2. Annex 3 series, my lord. Of my writ petition, my lord.
52 is the affidavit. Annex 3.
3 series, yes, my lord.
52, can it be 52?
My lord, maybe
Is it 78? To whom it may concern?
no, my lord, page 52. This is my lord, the draft notification prepared by the Deputy Commissioner, my lord. It's just
Are you referring to writ petition number 35?
no, my lord. 201, my lord.
What I sorry. Yes, sir. Yes. Yes. Okay.
Yes.
52.
Yes, ma'am. This is the draft notification prepared by the Deputy Commissioner, my lord.
Draft notification, you're right.
Yes, ma'am. And then, my lord, this is also the cost of land annex of page 53, my lord. This is not relevant, my lord.
Draft notification of 15th of March.
Yes, my lord. 2018.
Yes.
This is all internal communication, my lord. Then, my lord. Page 54, my lord. This is the notification, this is the substance of notification.
But page 52 has the name of respondent number 4 against serial number 1.
Yes, my lord. Yes, my lord. That is why, my lord, no paper publication, my lord. Everything was done internally, my lord. Clandestinely, without our knowledge. Now, my lord, this comes, my lord, after 15 March, my lord. This is the notification, page 54, my lord. Prepared by the Secretary Land Management. Well, I am repeatedly saying, my lord, I was not in knowledge of this notification, my lord. I have collected this notification from writ appeal number 1. Now, state has come with the entire, my lord, notification, my lord. 24/4/2018, my lord. Now, my lord, this is the substance of notification, which was to be published in the local daily, my lord. I do not have second page of this notification, but state has the notification. My lord, may please travel your lordship.
Mr. Ram, did you go for paper publication or the publication which is envisaged? Where are the publication? Just show us.
We have sent it to the IPR department.
No, that is not enough. Where is the publication?
They have not produced one.
There is the only statement from the.
No, the statement will not do. If it is a requirement law, these are a compulsory acquisition.
Yes,
Whether the beneficiary is Mr. Biswas or Mr. Picha, that is the secondary outlook. First is for compulsory acquisition. There has to be, you have to adhere very, very strictly to the requirement of law. That is the principle.
I
Sending it to DPI or IPR will not be enough.
No. Yes, sir. It is true. I agree. It is the only submission, only statement made by.
No, what you have been instructed, you will say. But if you are not, if you say that there may be records, that is a different matter. But this matter is pending since it has flown through a lot of water has flown in the meantime. Now, is there a paper publication?
Then I have to take instruction.
My lord, before that, may I, if I
Yes.
permit, before the DB, my lord, the entire case record is summoned by this court, my lord. The court honorable learned DB has examined the records, my lord, and passed the judgment. All these points was raised by the ITBP at that point in time. In no notification, there is no, it is a government land, there is no determination. Everything was raised by them. And then finally, my lord, the DB judgment has come last year, November 2024. That is, lordship may take up my I8.
My lord, this one pending, that earlier writ petition, I will clarify. My lord, may please come to page 215.
They find a police complaint also. Police also investigated saying my antecedent is from a different village. I have.
No, we are not on.
Right.
Where are you from?
Right.
We are in the presently, we are in the aspect whether the mandate of 2013.
Exactly, my lord.
Yes.
There are two single judge judgment, my lord, upholding this fact, all this while these grounds were taken, division bench order, Supreme Court order, my lord. I have
No,
to,
but on fact, the state council is saying that he doesn't have the.
my lord, the entire, the same ground was taken, records were summoned, my lord, and it was examined, and then the judgment was passed, my lord.
Where?
My lord,
My
the
lord-
judgment is, if your lordship take out
Just
my.
put the picture, just 1 minute.
Yes.
Page?
Lordship may have my list of dates.
No, you want to see the judgment. Page?
Yes, so I will just straight away, my lord. Lordship may have my IA 35.
Yes, page
Page number 161.
161.
Yes, my lord.
Yes.
Yes, my lord. So 161, my lord, is the starting. Lordship will see it is on 22nd of November. Then relevant part, Lordship will straight away come to para number 45, 46 at page 180. Page 180.
Just a minute, please.
The single judge order was by your lordship only in 2022. That was challenged in the second round by ITBP. 180. Page 40, para 45, 46 is the finding, Lord. May I read?
180. Yes.
Yes, my lord. So just before that, my lord, just the previous page, my lord, they have reproduced section 37 and then page 45. The
Para
appellants-
45.
Sorry, para 45. The appellants herein, by way of their conduct as demonstrated from the proceedings in the matter, both before the reed court as well as before the division bench of this court, has permitted the land acquisition award dated so and so have attained its finality. The appellants herein, having not questioned the awarded amount in the manner provided in the Right to Fair Compensation Act, and the learned single judge by judgment dated 7/11/2019 passed in writ petition so and so, having directed the appellants herein to deposit the awarded amount with the jurisdictional deputy commissioner as such, being passed after considering the objections raised in the matter by the appellants herein and the rejection thereof, the appellants, by way of reiterating the very same objection, could not have instituted the connected writ petitions being so and so based on the same grounds as was raised by it in the earlier round of litigation involving proceedings so and so. Para 46, my lord.
Yes.
The conduct of the appellants herein in the light of the various orders passed by the court in the connected proceedings would reveal that the appellants are only by trying to institute proceedings one after another, seeking to delay the disbursement of the awarded amount involved in the land acquisition award dated 6/9/2018, and thereby causing prejudice to the private respondents herein. So 47, 48 is also on res judicata finding, my lord. The direction your lordship will find at page para 51, page 183. They have imposed cost of 25,000 also on the ITBP. 183, lordship has page 183. Para 51. In view of the above discussions, we are of the considered view that the order dated 8/9/2022, that is a single judge order passed by learned single judge in so and so, is not erroneous and would not call for any interference. 52. Noticing that the appellants herein had instituted connected writ petitions and writ appeals before this court.
But in this proceeding,
Yes, my lord.
you are the writ petitioner.
In this proceedings, my lord, ITBP was the writ petitioner.
No. ITBP was the appellant.
Before the division bench. Yes.
Division bench.
No, my lord, what they did is, that's why the list of the, initially, my lord, I was the writ petitioner. A single judge directed they inquire, find out whether it's government land or not. If not, then proceed as per the land acquisition. They decided, notification issued, award passed. my lord.
But this challenge is on a different footing altogether.
Yes. My lord, identical issues, identical grounds. There's no notification. Lordship may summon the appeal
Those were in the on the challenge made by, not by him.
Not by him. Correct, not by him. But now, my lord, there are two division
Who
benches.
had taken up the issue that there was no notification, no publication?
ITPP, my lord, Union of India, repeatedly, in two writ petitions, and finally writ appeal and SLP also. And then
Where is the finding that there were publication?
my lord, lordship will see, because there is, if your lordship will see para 9 of this judgment.
Para 9.
Lordship has page 168. Married?
Just a minute, just a minute. Move to 16.
168, my lord.
Yes.
Yes, my lord. So para 9, my lord.
Hmm.
A perusal of the judgment of dated 9/11/2019, passed by the learned single judge, would go to reveal that the contentions of the appellant's hearing that they had disputed the rate as fixed by the jurisdictional deputy commissioner for the lands involved in the land acquisition award, notified on 6/9/2018, and further that the ownership of the land itself being in doubt, that is, as to whether the same was community land or government land, there was no necessity to pay the awarded amount unless factual aspects are clarified, was duly noticed. So, my lord, everything.
No, that was the different, that was a different point, whether it was community land or government land.
Yes, my lord.
Now,
There-
his contention is on the aspect of publication. So
No.
was the finding on publication.
My lord, finding on publication, the grounds were there, my lord, but then
Now, where is the finding?
because the court finally went into, my lord, because the LA appeal also has attained finality. The court did not give specific finding on each issues, but court held ki repeatedly they are filing, and the LA appeal also has been dismissed. They have not taken any recourse against that LA appeal, and only way to challenge.
No, that was an appeal by the ITBP.
Yes, my lord, but
He is on a different footing altogether.
but even, my lord, in
He is saying that
under the Land Acquisition Act, my lord, anybody wants to challenge the award, my lord, they have to follow that process. Therefore, they had filed initially, they had filed an IA in the writ appeal also, but they withdraw that. And then they filed a fresh round of writ petition. Because the only remedy available to them now is, my lord, to challenge that order or the LA appeal, which was dismissed long time back, because there is no reference. Now, after 7 years of the award, my lord, they have come up. Once the Supreme Court directed to deposit the payment, and then only we will see what has to be done, my lord. Ultimately, Supreme Court also dismissed the SLP. Now, once the payment was deposited, my lord, in 2023 March, they came before for the first time they came up. They filed a complaint before the police saying that I am not from that village. Police made an investigation, filed a report closing that case, my lord. And after that, my lord, they went to the DM also. But it has been after 7 years, my lords. So unless they challenge that award, my lord, or the
Mr. Picha, all this time the proceedings were going on, you were not even aware.
No, my lord.
Why?
So, no paper publication, we were
No,
not aware.
that is on the aspect of acquisition.
Yes, my lord. In the year 2023, we came to know, my lord. We filed an FIR, we filed a representation before the deputy commissioner, nothing done, my lord. Now, in the meanwhile, we came to know that there is a writ appeal pending before this honorable court. We filed an IA application for impleadment. Now, this honorable court has cautioned us, my lord. If we enter in the writ appeal, our right would be, my lord, vanished, my lord. We will forgo our right, other rights. That is why, my lord, this paper publication all, because that plea was not taken in all the writ petition and the writ appeal, my lord. So this honorable court itself has cautioned us. So we have withdrawn our IA, and then we have filed this writ petition.
Page 99, because their primary ground, my lord, now today is that I am not from that village. That is the primary ground. Because in the writ petition also, they are taking the main ground that I am not the party. So only available way, my lord, because
When was, what is the date of the award?
2018, my lord, 6 September 2018. And thereafter, my lord, 2 rounds of litigation. 1 round till Supreme Court.
Oh, what is 64?
64, my lord, is a reference, my lord, to the authority under chapter 8.
On earlier 18.
Earlier 18, my lord, which was not done.
This does not cover us, my lord.
Any person interested who has not accepted the award in acquisition. But he was not even a party to the proceedings.
My lord, even if your lordship see
How does
37,
it take recourse to 64?
my lord, 37, my lord.
37?
Kindly see, my lord.
Yes.
May I read?
Yes.
Finality.
Yes.
Award shall be filed in the collector's office and shall accept as herein after provided be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, of the true area, market value of the land, and the assets attached thereto, solitium so determined and the apportionment of the compensation among the person interested.
Hmm.
For all these purposes, here it is basically an apportionment, my lord. For all these purposes, my lord, even if he has not appeared, my lord.
No, apportionment if he is a party to the proceedings. Yes. Now, he was not even a party to the proceedings.
So
The
there-
LA proceedings,
Yes.
did it go to the stage of 64? No.
My lord, it went straight to 74, my lord. What?
No, 64 was taken into taken into recourse. No.
64, what the ITPP has done, my lord, they were never in the picture. 74, they filed an appeal before the High Court directly under 74.
No, that we have said that unless there is a reference.
Correct, that cannot be
and
done.
Answered by the
So
reference code.
therefore it was dismissed, my lord. But all this while, my lord, 2 rounds of writ petition, which ultimately went into DV and then the SLP also, my lord. Similar grounds, my lord, was taken, though they were not there. Now, my lord, after 7 years, and there is a limitation also, my lord, lordship will see under 64, maximum 1 year. Because 64, if your lordship see,
No, 64, will
Will not come
64
into play.
at all apply to him?
No.
Any person interested who has not accepted the award
yes, my lord,
may.
yes, my lord.
Award has been passed, he is not accepted, that's a different matter.
Yes.
He is not even a party to the award.
Yes, ma'am.
My lord, he is not, because he, even if he doesn't appear, my lord, because
There-
that's why it has to be
there
read
are
with 30,
issues, Mr.
that it
Mishra.
has to be read with 37, my lord.
There are issues which may have to be reopened.
My lord, the 37, if your lordship kindly see 37, even if who has not appeared before the
30?
37, my lord, which I have
Was
just,
he given notice?
Yes.
my lord, public,
After issuance of notice,
my lord, this is a public notice given.
where?
No.
Let us see.
Yes, ma'am.
They are not being able to show us.
Yes.
My lord, the government has
Not
filed.
only a public notice, under
Lord,
this
can-
act, maybe under the 1893 act, the prescription of notice is a very rigorous one.
Mandatory one.
Yes, my
Not
lord.
only mandatory, it's a very rigorous one. How do you do it? Even by a beat of drums.
Yes.
Everything is prescribed.
Even, my lord,
The objective is that anyone who is affected will get a chance to represent himself.
yes, my lord. So, my lord, even the government has filed an affidavit, my lord. If the affidavit is dated for 14th of May, 2025.
But if Mr. Riram is not being able to conclusively say that there was a notice given, accept the statement in the affidavit,
My lord, today, my lord, there are 2 DV bench judgments, my lord, upholding this.
so we are not on there. We are not, there's nothing to, we cannot, as a single bench, we cannot say anything about the DB, but it's a different point altogether.
Yes.
Was it the point of consideration before the DB?
My lord, therefore, my lord,
Certainly not.
my lord, therefore, my lord, in the, as per the act, my lord, they have to challenge that award, my lord. They cannot file writ
We have challenged the
petitions.
award, ma'am.
They have to challenge the award in the known procedure known under the act, my lord. They have to go back to the, either they have to challenge the DB order or they have to file a reference. So
Reference by whom? How will the reference code determine whether he is a beneficiary or you are the beneficiary? The question of apportionment will come later.
Yes,
But first, we have to, since he is raising a question for the first time, that LA proceeding was not instituted in accordance with law. Maybe his primary interest is regarding the compensation that he's been deprived of.
Yes, ma'am.
But to make a grounds, he says that, yeah, I have a legal ground also. Can he be deprived of the legal ground?
my lord, the government files an affidavit, my lord, and in that affidavit, they say that the petitioners have come to the court and before the DM only for the first time.
Mr. Bariram, you have the original records of the proceeding, land acquisition proceedings? Do you have the original records of the proceeding? Get the proceeding records.
Lordship may also summon the writ petition,
No, we are not on the writ petition records are here.
writ appeals, my lord,
No,
which
not
the DB
required.
bench.
You have annexed. We are not too much concerned with the order passed in the writ appeal.
Very well, my lord.
We'll be concerned with the points taken up for the first time by the petitioner.
My lord, may I make one submission, my lord, just for,
We'll have the records called for.
yeah, very well, my lord.
Tell us a date. Tell us a date. When can you get it? 2 weeks?
No, yours. And it's the 5 minutes.
3 weeks. We give a date.
Please vote.
No, give a date, 3 weeks.
No,
It is of which year?
24.
Okay, well, heard, 3B Picha. Learned counsel for the petitioner. Also heard. 3Y Riram Learned State Counsel for respondent numbers 1, 2, 3. Sri so-and-so, learned counsel, has represented Sri M. Katuk, the deputy SG, for respondent number 4 to 6, and Sri R. Biswas is present for the respondent number 7. Full stop. Your IA is for what?
For vacating the interim order.
Okay. Respondent number 7, who has also filed IA number so-and-so for vacation of the interim order.
Yes.
Full stop. Tara. Sri Picha, the learned counsel, has submitted that the proceedings which had culminated in the award that in the proceedings, in the land acquisition proceedings, which had culminated in the award, comma, it is the respondent number 7 who is the beneficiary.
Yes.
And
Along with 4 others.
as 7 is one of the beneficiaries along with 4 others. Full stop. He has submitted that the entire process is vitiated by fraud.
Yes.
As the respondent number 7 is not even a resident
Yes.
of the locality and therefore is not a person interested at all. Full stop. He has submitted that the proceedings were conducted in gross violation of the provisions of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, bracket herein after the Act of 2013. And he has specifically mentioned sections 11 within bracket 1 within bracket small b, comma, 11 within bracket 1 within bracket small c, comma, 11 within bracket 1 within bracket small e, and 11(2). He has submitted that there was no publication of the acquisition proceedings, and the same was done in a hush manner without and was not transparent at all. But if it was acquired, why weren't you knowing your land was taken away?
It was already in possession with the ITBP since 2005, my lord.
Okay. He has submitted that since the land in question was already under the illegal occupation of the ITBP before the proceeding had taken place.
Before acquisition.
Before the proceeding had taken place.
Yes.
Comma, there was no occasion for the petitioner and the community to know about the proceedings. Full stop. He has submitted that if any fraud is detected in a proceeding, comma, at any stage, such proceedings can be questioned and interfered by the courts. Full stop. Per contra, comma, Sri Biswas, the learned counsel for the respondent number 7, has submitted that the issue was already raised in earlier rounds of litigation instituted by the ITBP, which had also
final.
Which was and the decision of the learned single judge was also unsuccessfully questioned by unsuccessfully assailed by the ITBP. And once the issue has become final, comma, there cannot be the same cannot be reopened by another writ petition. Full stop. He has submitted that the petitioner can take recourse of the act itself by praying for reference. Full stop. Tara. Without even going to the aspect whether the petitioner would be in a legal position to avail the recourse of section 64 of the Act of 2013, this court has put a specific query to Sri R. the learned State Council on the aspect of publication of the notices under the Act, full stop. He has very fairly submitted that though such a statement has been made in the affidavit, there is no enclosure of any such notice or paper publication, full stop, para. To dispel any doubts or ambiguity, this court directs the Learned State Council to produce the original records of the land acquisition proceedings to look into the said issue, full stop. This court is of the view that the issue raised, that this court is of the prima facie view that the issue raised in this petition was not the issue in the earlier rounds of writ petition, and therefore there was no occasion for the court to consider and answer the same. Full stop. This court at this stage would also like to, is also reminded of the observations made by the Honorable Supreme Court in the case of so and so, wherein it has been, wherein the Honorable Supreme Court, after referring to certain referring to earlier cases, including the case of Lazarus or something, I will put her, had made the following observations. First of para, we put the observation. The Justice Kuldeep Singh, what was it? Page 1. 2000, what was it? 2004, 1 SCC, page 1. I don't know. Do we have a judgment on fraud? Page 1. Justice Kuldeep Singh. Fraud vitiates everything.
Fraud, my lord, yes, my lord. I have one judgment.
No, the landmark judgment of Justice Kuldeep Singh. Ledgerers versus something has been quoted.
One, I have 2007 4 SSC.
No. Earlier than that. 1996 or something. Page 1. That is, I know. Page
Yes,
1.
on page 1. Yes.
What is it?
Paragraph? I have not got it, my lord.
Okay, I will put it. Para. Let the records be accordingly produced. Full stop. Let this matter be listed for perusal of the records on after 4 weeks. I'll give a date if you are coming from
Yes,
outside.
sir. And
After 4 weeks.
after 4 weeks, any date?
On
Probably just
today is 22nd.
yes,
1, 2, 3, 4. We'll have it on 28th, Mr. Biswas. Is it
28th
okay?
of June.
Yes. 20, Mr. Picha.
Yes, my lord.
20. 20. Okay.
Yes.
In the affidavit, they say it has been published in the newspaper, but there is no.
We have to see the publication.
This SP Chengalwala Naidu. my lord.
Name.
SP
No,
Chengal.
sorry.
versus
Citation.
1994 1 SSC 1.
Yes. That is one. That is Kuldeep Singh. Yes. 1994.
1 SSC page
1
1.
SCC 1. Yes. I'll give you the. You have the quotation there. What was the English law? Ledger or something?
2007 it is there, my lord. This is of my lord.
Just let me have a look.
My lord.
Ledger or something. You have 94 1 SCC 1. Please give 94 1 SCC 1. No, not this one. 94 for 94 for Lauto. Yes, Lazarus Estate versus Bisley. 1956 All England report. Lazarus Estate, that was taken into consideration. Lazarus Bisley. We come to page paragraph 22.
Yes, my lord.
In the
21.
leading case of Ledgerus Estates versus Bisley, Lord Denning, no judgment of a court, no order of a minister can be allowed to stand if it is obtained by fraud.
Yes, sir.
That is the first. Then fraud vitiates everything, as in quoted in Aspi Changa Naidu. Kuldeep Singh. Yes. Okay, next.
Obliged, sir.
Obliged.
May I please, my lord?
Yes.
My lord, this is for compensations for illegal arrest and detention.
Illegal arrest compensation.
Yes.
By writ court.
Yes, ma'am.
By writ court.
By writ court, my lord, yes.
Yes, what do you say?
No,
You're
sir.
for whom?
I'm for respondent number 4, the investigating officer.
You are made party by name.
Yes, ma'am.
Yes.
You are seeking compensation against him, from him,
It's from state, my lord.
from state. Yes, state. Why don't you pay compensation? How much compensation are you seeking?
Randomly 5 lakhs, my lord. I will leave it, my lord, sir.
Now, first, you have to establish a case
Yes, ma'am.
that your detention
Yes, ma'am.
and arrest
Yes,
were not in accordance with law
yes, ma'am.
or vitiated by malafide.
Yes, ma'am.
What are the provisions under which you were arrested?
My lord, I was arrested,
What provision of law? What sections?
354, assault or criminal intimidation to women, 1 year extendable to 5 years, and voluntary causing hurts, up to 1 year.
Okay. What happened to the investigation? Final report.
Not, my lord, not yet.
Then
My lord, what happened here?
investigation are done or not?
Still going on, I think.
Then how do you?
Now, my lord, what happened? FIR was closed against me, and pending that arrest, I come before this court by way of prayers bail, my lord, applications. Then this court granted the interim prayers bail, my lord. Then I went to the police thana. Then even I produced I-card and security, bail bond, everything. They have arrested my lord.
You had an interim
Yes,
bail.
on my interim bail, they have arrested me, my lord. My lord, would clear, my lord, order of this court. Thereafter, I was produced before the CGM and I was remanded for 14 days, my lord.
What about the order of the High Court?
Yes, ma'am.
What about the bail order of the High Court?
Bail order of the High Court, my lord. It's been made absolute, my lord.
No. When you were in possession of a bail order by the High Court.
Yes, ma'am.
Why wasn't it taken into consideration by the police and the CGM?
Well, but they are saying that I was not, what's called, I was not, just wait a minute. Cooperating with the IO, my lord. The IO was accused to produce the car and the weapons. Then he failed to produce the car and weapons. Then therefore he arrested the accused persons.
Yes, how can you do so? Without taking a leave, without cancelling the bail. He may not be cooperating, he may be jumping bail or he may be doing activities illegal. You have to get the bail cancelled.
These are all courts given the interim bail.
Yes.
And some conditions have been given. And he is supposed to fulfill those conditions before the IO.
Let us see. Where's the bail order?
Yes, right. My lord, page 18, my lord.
18.
18, my lord. Annexure 2, my lord. Relevant, my lord, 9.
According to interim order, the satisfaction or arresting order, they appear for investigation 7 days.
7 days. Accordingly, I appeared on 9th, my lord. And
8-2. 8-2 is the order. 8-21 is the order.
yes, my lord.
Yes, you had appeared then.
Then, my lord, on 9th I appeared, they refused to take bail bond. And on next day, my lord,
on 10th, my lord, I again appear, they asked me to deposit the bail bond on the account of CGM. My lord. Accordingly, I deposited. My lord will find the receipt on page 24, my lord.
Yes.
On 10th, my lord.
What do you do?
I'm my lord public leader, my lord.
Huh?
Public leader, my lord.
Public
Leader.
leader. Yes, what is this going on?
Kindly take up my lawsuit affidavit. I've given some explanation. Can you see this? This affidavit filed by respondent number 2 and 3.
No, no. This cannot go on. This cannot go on. What is your explanation?
Lordship, I have tendered my apology because I was working.
What
on
will
the-
happen to the aspect that he was handcuffed, taken to the jail in spite of, what is the kind of apology?
Lordship,
What about the humiliation he has suffered?
Lordship, there's, although he has submitted that bail bond amount in the account of CGN, but arresting authority was Women Pay Sitanagar. So according to the condition, he has to deposit that amount there, not in the account of CGN. However, that's why that the accused was taken to the this learned Chief Judicial Magistrate. And after considering Annexure 8, page 25, Lordship, here the IO investigation officer have forwarded the accused to alleged accused person before learned Chief Judicial Magistrate. And Lordship will find Annexure 9, page 28. Here, the order of the Chief Judicial Magistrate, Capital Complex, UP, on, may I read them? 11 to 2021.
Page
28.
28.
Yes. Annexure 9. Man, accused Benga Tabang is produced before me today by investigation officer SIR Singpo of Itanagar Women Peace. I have seen the forwarding report, FIR, arrest come, inspection memo, medical report of the accused. Accused been stated that his family is aware of his arrest. I have informed the accused of his right to file bail application. Accused stated that his family would engage advocate to defend him in the case. So he before the Chief Judicial Magistrate, he did not say that about that order or that he had deposited this everything. No visible injury found on the body of the accused. As far as medical examination report, accused was found fit. However, there is a medical prescription of the accused where it is stated that the accused is suffering from cough and fever and medicine have been prescribed by a treating doctor. I have gone through the FIR filed by Ms. So-and-so stating that on dated 30 January 2021 at around 6 p.m. accused picked up the informant from her house in his car on the pretext of getting her signature in the
Matter is very serious. Face the consequence.
Lordship, that's why.
You have to face the consequence.
Now, Lordship.
You cannot put the blame on the court. Where is the court's observation that he was equipped with an interim order?
That's why, Lordship. He also did not
Why should he? If you had a problem
Lordship,
with the interim order, get it verified.
Lordship, he deposited the amount in CGM court.
So if there was a problem, you should have taken the advice of the learned PP.
She have taken the advice from the senior officers.
Sorry.
Lordship,
you have to pay a huge compensation. Why only 5 lakhs? More than that.
Lordship, this,
More than that. This is not going, you cannot take law for a ride.
Lordship, this,
You
I
cannot
owe,
take orders of the High Court for a ride. You are aggrieved by the order, get it cancelled. If he has violated any order, get it cancelled. What was the violation?
Lordship,
Not
here
being able to
further
pay
it
the
has
bail
written
bond.
that I have forwarded the accused was granted interim
Sorry.
bail by Honorable Guwahati High Court.
Yes,
dated
what
7th.
case law are you relying upon? Any case law?
Yes, my lord, on compensation, my lord. There is a.
Just Lordship, I'll read one paragraph, then Lordship.
No, he'll be personal liable.
Lordship,
He'll be personal liable. You,
Yes,
did-
I'd like to place under what circumstances this had happened, Lordship, because circumstances is very important to decide this. Lordship.
yes.
Here, Lordship, the bail has been granted, Lordship, but the condition has not been fulfilled.
What is the condition?
Condition to punish the security, Lordship, and the amount has to be deposited.
He had deposited certain amount in the CGM's thing. For that trivial thing, will you arrest him?
No, therefore, Lordship, it has been explained here in my opinion. Kindly, Lordship,
Yes.
may.
Yes, please read.
The investigating officer is said so and so, on particular, Mr. Locum Mone appear a eternal woman PS with the interim bail order number so and so, copy issued by the Honorable High Court. So and so, Nagaland, contrary to the claim that the alleged visited himself with his wife so and younger brother so and so. On that day, he didn't appear himself. He sent his wife, the younger brother. On demanding the presence of the alleged accused as required under the directives of the Honorable High Court for an interim bail order, Mr. Locum Mone failed to do so. Hence, he was advised to present the alleged accused to execute the pre-order arrest within 7 days from so and so. The following day, that is on 10/3/2021, Mr. Bengia Tapang visited the woman PS along with Mr. Locum Mone at around 12:15 hours and was formally arrested under the witness of Locum Mone, researcher. Upon interrogation, the alleged accused failed to cooperate despite the proper instruction given by the investigating officer on submissions of bail amount.
Mr. Tapin, before his non-cooperation, you have already arrested him.
Close.
What you have just read,
Close.
upon interrogation,
Close.
prior to that, you have already arrested.
Yes.
Kindly see the order of this court at page 19. It is an interim bail in an anticipatory bail matter.
Close.
In the event of arrest,
And he has to be released.
he has to be released.
And
Now,
for-
kindly see what was the observation of this court at page 19. Please
Page
read.
19.
Please read.
The petition so and so.
No, considering page 19.
19. Considering the materials available in the record, this court is of the opinion that the petitioner deserves to be given interim relief. Accordingly, as an interim measure, it is hereby directed that in connection with eternal moment PS case number so and so, the petitioner namely so and so shall be released on bail on furnishing of bail bond of rupees so and so with a security of like amount to the satisfaction of the arresting authority. The petitioner is directed to appear before investing within so and so and so.
So the direction to appear is a different direction, and a direction to release him on bail is a different direction.
Different direction.
So when did he appear?
He appeared on 10 laws. Instead of 9, he appeared on 10. Earlier, he sent his wife and his younger
No, there was not requirement for him to appear on 8 or 9 or 10.
they-
He was given 10 days
No,
time.
that's okay. That's okay. Within a particular period, he can appear on any date.
Okay, when was the problem you have got regarding the bail bond? Which date?
bail bond, Lordship, he submitted before CGM
When?
on 10th.
10th. And when was 10 days expiring, 7 days expiring from the date of the order?
Yes, Lordship. This why in the order of Chief Judicial Magistrate, the Chief Judicial Magistrate clearly said that accused appeared before police did not furnish bail bond and surety as directed in interim order. That is why. That's why he was taken
Here,
to
Lordship,
Chief
I have
Judicial
given a
Magistrate.
statement that he failed to.
Yes.
His failure
Close.
to furnish the bail bond will be crucial or important for the 7 days. Petitioner is directed to appear before the individual. This was the condition.
Lordship. Here, Lordship, one thing is, Lordship. Once, Lordship, When
My
he
lord,
appears
this-
before the
this issue
investigation,
And
once he,
regarding the bail bond also, he has submitted before CJM, not before the particular court. How should we arrest him?
Lordship, what happens is when appear, he will be arrested, then he will be released after furnishing bail bond. Now, what he did, he furnished the bail bond in CJM court, that's why he was taken to CJM court.
because Lordship, arrest is one thing, Lordship.
Yes.
Once he is arrested, Lordship, because so far arresting part, this honorable court has no much say, Lordship. Only he has to be released, Lordship. That after fulfilling the condition, Lordship. He has been arrested, but he has not fulfilled the conditions. So therefore, he was kept in the Lordship custody for that night. On next day, he has been produced before the magistrate concerned, Lordship. And magistrate concerned affirmed that order, and he has been kept sent to the judicial custody for further days, Lordship. From next day, Lordship.
This is not how you construe court's order.
This issue has been, my lord, in IA also, it's answered, my lord. I filed during my arrest. I filed IA before the
We have seen page 20 to 31.
Yes, yes.
We have seen this.
Now, Lordship, question is, Lordship, when once he has been arrested, Lordship, to release, Lordship, condition is there, Lordship.
My lord, this court order dated 02/12/21 also observed, my lord, order dated.
This observation at paragraph 7 has attained finality at page 32.
In subsequent lawsuits, by subsequent order laws, he has been directed to file affidavit by seeking, by giving apology lawsuit, and accordingly, he has even filed affidavit also.
Will not be enough. He is not seeking an apology. He is seeking compensation.
And then that part we see.
It is not a contempt. He has already suffered loss, huge loss, which cannot even be compensated by in terms of money. It is not a house being demolished, again you build the house.
Issue is possible, the one condition is not fulfilled, how he has to be
He
released.
should have deposited that amount before the arresting authority, and suppose, okay, he have not deposited that, then if he has deposited in CGM court, then he has to be taken to CGM court.
My lord, CGM account numbers hang on their police thana. They saw the numbers, account numbers, and asked to deposit there. Therefore, this particular person, money, has deposited the amounts. How could that money will know that CGM account numbers, my lord?
And
He has also given documentary evidence of depositing in the CGM's account. If there is some trivial error, do you arrest a person or did you give him a chance? He had 7 days time to appear. That was not exhausted. This bank the deposit is which state?
So he appeared around 12 and he deposited around 2:30.
So,
And then before CGM, also, and during Corona period, government PS in here,
10 to.
he
10
has,
to. He had 7 days time to appear.
yes.
It was done on 9th, he had gone. 10th, he had deposited.
Yes. On 11, he could have submitted it before the IO. That yes, I have submitted bail bond before CGM. He could have submitted this before IO.
IO is very smart. We
Lordship,
know how to deal with smart people.
Lordship, this
Yes, you have to face the consequence.
Lordship, I have tendered my apology, Lordship.
That is not enough.
And Lordship,
Not
yeah,
enough.
I have acted under.
Will you be behind the bars for 14 days? Then he'll tender an apology to you.
Lordship, I have acted under this instruction of my seniors and magistrate, Lordship. Lordship, I am a very young. I am a mother of one, and I'm very young of.
No, you need to be. You need to know what is the restriction of law. Where is the affidavit? Where have you stated that you have acted on the instruction of senior officers? We'll implement them.
Yes, there.
We'll implement them.
Lordship, respondent 3.
We'll implement them. you will have to face a disciplinary proceeding also. Where is the statement?
Lordship, we have tendered the apology here. So
No, you said that just now that you have done and the instruction. Where have you stated? You have not stated.
Yes, Lordship.
Just now you have made a statement.
Not stated, Lordship.
Then why are you making a statement without there being pleadings?
Lordship, here actually, Lordship, this IO is very honest and she is state awardee also, Lordship. This one mistake and then two under.
There is a mistake which cannot be pardoned. You have put a person in bar for 14 days
Lordship,
in spite of having equipped with an order of this High Court.
Lordship, I am just the IO, Lordship.
Where is the rule of law?
It is there, Lordship, but Lordship here, she is just the IO, Lordship.
We will also ask disciplinary proceeding to be initiated against you.
Lordship,
Don't play with the law like this. Heard. 3. So learned concept for the petitioner. Also heard 3 so the Estap in learned senior government advocate for the respondent numbers 1, 2, and 3. Whereas 3 has learned concept has appeared for the respondent number 4. Full stop. A very serious issue has been raised in this writ petition, which touches upon the very aspect of the rule of law and adherence to orders passed by the court. Full stop. Para, as per the facts projected, an FIR was lodged against the petitioner, being FIR WPS case number so-and-so, under so-and-so. Full stop. Apprehending arrest, the petitioner had moved this High Court wide for anticipatory bail, wide AB number 50 of 2021. And this court, wide order dated 8/2/2021, had granted an interim measure with a condition that the petitioner shall be released on bail on furnishing a bail bond of rupees 10,000 with surety of like amount, subject to the satisfaction of the arresting authority. Full stop. It was also provided that the petitioner would appear before the IU within 7 days from the date of passing of the order. Full stop. For ready reference, the relevant observations made by this court is extracted herein below, page 19. Para, it is the case of the petitioner that on the next date, that on the next date, that is 9/2/2021, he along with his wife, younger brother, and son-in-law had appeared before the Itanagar Women Police Station. However, the IU, within bracket respondent number 4, had refused to receive the bail bond. Full stop. Thereafter, on 10/2/2021, the petitioner had again appeared before the IO along with the aforesaid 3 persons for execution of the bail bond and surety. Full stop. However, in spite of the said action, the petitioner was arrested at 12:29 noon on 9/2/2021, and an arrest memo was issued. Full stop. He was remanded to police custody. He was kept in police custody, and only on 11/2/2021 he was produced before the court of the learned CJM, whereafter he was remanded to 14 days of judicial custody. Full stop. The petitioner, being faced with such circumstance, had filed IA 04/2021 in the pending AB 50/2021, and this court had issued an order dated 12/2/2021 directing release of the petitioner from custody immediately, which was accordingly done. Full stop. 3. Tari, the learned counsel for the petitioner, has submitted that the aforesaid action of the respondent number 4 is not only in gross violation of the principles of law, but is an action which is wholly against the rule of law. He has submitted that proper bail bond and surety was furnished. Full stop. He has also submitted that it is on the instruction of the personnel in the police station that the amount mentioned by this court as bail bond was paid in the which page? Bank receipt.
There's 24. There's 24 is the receipt.
24.
Yes, sir. Annexure 7.
Paid in the account pertaining to the whose account is this?
Chief Judicial Magistrate.
But account of the Chief Judicial Magistrate. And in this regard, he has drawn the attention of this court to Annexure 7 containing the receipts issued by the bank. Full stop. He has also annexed certain photographs. He has also drawn the attention of this court to the arrest memo issued on 10/2/2021, and also certain photographs wherein the petitioner was handcuffed. Full stop. Para. The learned counsel has submitted that the action of the respondent number 4, apart from being illegal, is unpardonable, inasmuch as the petitioner, in spite of being protected by this court, was arrested, which had caused immense harm to his reputation. Full stop. Para. Justifying his approach to the writ court to seek compensation. The learned counsel for the petitioner has relied upon the case of the following cases. 1, 2, 3 in chronological order. Para. In the landmark case of Radul Shah, the Honorable Supreme Court has laid down that for violation of Articles 21 and 22 of the Constitution of India, monetary compensation can be directed to be paid by a writ court. Para. In the case of Bhim Singh, the Honorable Supreme Court has come down heavily on arrest with mischievous and malicious intent, and had also directed payment of compensation to the victim of such arrest. Para. This court in an order dated 2012-2023 passed in WPC 2783 of 2021 had also directed for payment of monetary compensation to the victims of illegal arrest and handcuffing by holding that such action is violative of section of Article 21 of the Constitution of India. What's the para? 3. Tapin, the learned state council, has however opposed the writ petition by submitting that though an interim bail was granted to the petitioner by this court, he had failed to adhere to the condition. Full stop. He has submitted that furnishing of the bail bond and surety were the basic conditions for the order passed by this court, which was not fulfilled, and therefore there may not be any error or illegality in the course of action adopted by the respondent number 4. He has submitted that the respondent number 4 in his affidavit has also sought apology for any error. Para. 3. You Bori. Sri Bori, the learned counsel for the respondent number 4, has submitted that all actions were taken in accordance with law and there was no mala fide intent. He has submitted that the principal condition of deposit of furnishing bail bond and surety was not complied with by the petitioner when he had attended the police station, and accordingly, he was arrested on 10/2/2021. Full stop. The learned counsel has, however, submitted that in the event this court is of the opinion that any error has been committed, the respondent number 4 has tendered sincere apology. Full stop. Para. The petitioner has filed a rejoinder affidavit to the affidavit in opposition of the respondent number 4, whereby the stand taken by the said respondent number 4 has been objected to. Full stop. Para. In the instant case, it is not in dispute that in spite of there being an order of this court granting interim bail to the petitioner dated 8/2/2021, he was arrested on 10/2/2021. Full stop. The operative part of the order dated 8/2/2021, which has already been extracted above, would clearly show that apart from granting an interim protection to the petitioner, that he would be released on bail on furnishing a bail bond with surety, as mentioned in the order. The petitioner was directed to appear before the IO within 7 days from the said date. Full stop. It is on record that on the very next date, the petitioner had appeared before the IO, on which date the issue of bail bond was raised, and accordingly on 10/2/2021, the bail bond was furnished, and in this regard, as noted already, the petitioner has also annexed the bank receipt. Full stop. However, on 10/2/2021 itself, at 12:29 noon, the petitioner has been arrested. Full stop. One explanation has been given that the amount was deposited in the bank later in the afternoon, and therefore, as on the time of the arrest, no bail bond was furnished. Full stop. Even without going to the correctness or otherwise of the time when the amount was deposited, what this court has noticed is the petitioner was granted 7 days time by this court by the order dated 9/2/2021, and he could have very easily appeared on the 7th day also. Full stop. However, even waiting for a couple of hours, even assuming that the amount was deposited in the bank in the afternoon, the arrest was made. Full stop. Para. The investigating agency may have good grounds to come for cancellation of bail if any condition is not fulfilled or there has been certain activities of the petitioner which would require such cancellation, full stop. However, the cancellation has to be done by following the due process of law, which requires an application to be filed before the court praying for cancellation. Full stop. Admittedly, the said procedure was not at all adopted, was given a total go by. And the respondent number 4 had taken the recourse of arresting the petitioner and having him in police custody. Full stop. Though a reference has been made to the order passed by the learned CJM, comma, a perusal of the said order would reflect that the learned CJM was not even appraised of the order passed by this court on 8/2/2021, and therefore this court is not in a position to make any comment on the action of the learned CJM. Full stop. Para. As laid down by the Honorable Apex Court in a catena of decisions, comma, when a case of blatant violation of the fundamental rights, more particularly those provided by those guaranteed by Article 21 is concerned, comma, monetary compensation can be granted by a writ court. Full stop. In the aforesaid case of Rudal Shah, the Honorable Supreme Court has made the following observations. There are 10. In the subsequent case of Bhim Singh, comma, the Honorable Apex Court had reiterated the said principle wherein monetary compensation was granted to the victim. Full stop. Para. In the instant case, comma, this court is of the opinion that the impugned action of the respondent number 4 in arresting the petitioner, which is in gross violation of the orders of this court, is also an action which is wholly against the rule of law. Full stop. This court accordingly has no other option but to allow this petition. Full stop. The respondent number 4 is accordingly directed to pay compensation of rupees 5 lakhs to the petitioner. Full stop. The aforesaid amount is to be deducted from the salaries. No, if the respondent number 4 fails to pay the amount, comma, the department is directed to deduct the same from his salaries, from her salaries, and pay the same to the petitioner. Full stop. This court also recommends the department to initiate appropriate departmental proceedings against the respondent number 4, as her action has been found to be totally contrary to the principles of law. Writ petition accordingly stands allowed.
Lordship, so for the last part is
We are
concerned.
recommending whether you take or not. is not-
It's a young lordship.
Young
this-
should be, young should know what is law.
Imposing 5 lakhs is, I think, enough for lordship. This last part maybe.
We are recommending whether you do or not. We are not saying initiate.
My lord, process of payments with
Lordship,
limitations.
Learned CGM was apprised about the dishonorable.
Let us show it from the order.
Yes, it is there, page 29.
Yes, what-
CGM's order.
What is the order?
It says that in forwarding report, IO has stated accused was granted interim anticipatory bail by the Honorable Guwahati High Court by order dated 8/2/21 in AV 50 of 21.
Thereafter,
However, the accused on his appearance before the police station did not furnish the bail bond and surety as directed in interim order.
okay. Yes, next.
My lord, process of payment.
You should be happy. Process of when you will get. Okay.